So what a pleasure to have you, Chinmay.
It's
I just went for a second because her voice was breaking up.
no problem at all, Chirag. So I would.
In fact, I must mention you, Kiran ma'am. It was because of support of Chinmay, we could have Dr. Vinodan, Mr. Subramaniam in the inauguration panel, and he has helped a lot
No, no,
in organizing this.
the pleasure is all
So it's
mine.
such a pleasure to
Uh,
have you, and we are really looking forward to your session.
okay. Thank you so much, Chirag and the organizers. So wish the distinguished panelists and dear participants, very good evening and good morning and afternoon, according to the time zones in which my fellow panelists are situated. And I would take this opportunity to thank the organizers for taking this uh, initiative to focus on disputes related to aerospace. That is sort of, I may say, a neglected area because of obvious reasons, but this is a great opportunity that there is some deliberation that is ongoing so that the laws can be developed further. So in this presentation, I would be focusing on the disputes which are currently taking shape in the space industry. And in this, I would cover, though there are a lot of potential disputes that are shaping up, I would broadly cover disputes related to utilization of celestial resources and slot frequency coordination, remote sensing legal issues, issues related to liability in launch services, then space security, and I would sum up my presentation with some suggestions as to how we can make the regime more robust and ensure that the global policy is sufficient to regulate such areas and no prejudice is caused to any of the space industry players. So starting with, I would start with the slot and frequency coordination issues. So the first issue that is very relevant is the issue of uncoordinated satellites. So as is the case that uh, ITU provides for a regime as to satellites to be first registered and then launched into orbit. There's a coordination mechanism wherein the satellite operator has to coordinate with other satellites in the vicinity or any other satellites which may suffer any harmful interference due to their presence. But there have been instances where without such coordination having been already done, satellites are put into orbit, and thereafter they in the simultaneously in the meanwhile they start the paperwork for coordination, but it presents a very unique situation that once the satellite is up there, it sort of pressurizes the other satellite operators in the vicinity or the satellites which may suffer from the presence of that new satellite. And they say that we are already here. So either you accept or else we would start uplinking and downlinking. We are capable of doing that, even if it is illegal. So then sort of a mediation is reached between the affected players, and then they reach some sort of mediation, and then the objections are withdrawn from the ITU, and then the satellites happily operate from there. This also gives rise to some sort of cartel formation. The satellites which are there, they would say that okay, you should not use this beam because we already have a beam there, we are doing business. So if your beam is also operating in the same area, then probably our business interests will get hindered. So what you can do is you can operate your other beam so that we are mutually coexisting with each other. So that is one issue which may give rise to various forms of disputes. The first form of dispute from this issue may arise in the form of sovereign governments objecting to private satellite operators playing out in the outer space. The other dispute that may arise is when harmful interference is being caused between two satellite operators. Because if two satellites are somewhere broadcasting in nearby spectrum, adjacent spectrum, then there are chances that the signals that are reaching Earth will sort of be contaminated with the signals of the other satellite. So that is one issue that is a big issue which needs to be addressed very soon. The other issue, that we are encountering currently is the registration issues related to low Earth orbit satellites. What is the current scenario? That low Earth orbit satellites are moving and are constantly on the move. They are not on one fixed position. But if we see the way the laws were formed, and ITU took the responsibility to ensure that the satellite are registered and then regulation is happening. At that time, there was no concept of LEO and low Earth orbit satellites. So the satellites were stationary in the geostationary orbits, and then the registration was sort of not a big problem. But currently we see that the low Earth orbit satellites are increasing in number in a very steep trajectory. In the last 2 to 3 years, we have seen more than 3,000 satellites currently launched to the low Earth orbit. And then as per the market projections, there are a number of mega constellations which are coming up. Some are already there, and they have phase 2, phase 3 plans. So the projection is that probably in the next 5 to 6 years, the total active satellites operating in the LEO can even touch 10,000. So how will registration issues be solved in such a case? The other sub issue of registration is now the satellites are capable of modifying their target beam transponders, which are communicating with the Earth stations in a particular geographical location. So say if I am a satellite operator and I have a particular satellite which is over at India, and I can do business in India by uplinking and downlinking from my ground station. But then I find no customers in India. So now the technology is such that if my satellite is of the recent technology, then I can move my transponder to, say, China. And say I am now operating in C-band, but then C-band is not having enough business. So then I can modify it to broadcast in Ka or Ku band. So in that case, where such changes are happening once the satellite is in outer space, is our international legal system and the national registry duly informed of such changes? Are such changes allowed in the current scenario? Do we have sufficient measures to ensure that everyone is complying with any changes that are happening? The other issue that is coming up is that say there's a satellite. Now the satellites are so technically advanced that they can have a broad geographical coverage area, and they can have a number of beams which would be, say, focusing on a particular geographical area. So there are satellites which are now capable of having a coverage of, say, whole of Europe and whole of Asia. So in such a case, satellite operators often want that to comply with the national laws where they are operating, they want to register a particular transponder in that geographical location, and the other transponder they want to register in some other geographical location. So that's a concept that is coming up, is space condo system. So like the whole satellite, they would be considering it something very similar to apartment complexes, and every transponder would be, say, very closely resembling to a flat. So they would be saying that this is a separate unit in itself. So I'm registering this transponder to operate over your geographical location, but at the same time, I can register my other flat for some other geographical location. So the technological advancements have happened, but has the law yet catched up to solve these issues? Should we allow such concepts to emerge? Uh, should we sort of bring some hindrance in order to ensure that there is no circumvention of laws? So what should be the case? This may also be a very emerging dispute, a potential dispute which may come around in the future. The other issue that we see is we are witnessing in the current times is the interference with the terrestrial frequencies. One very recent example is the launch of 5G in US. So there, the satellites had some frequencies, rights over frequencies to use certain frequencies, but with the expansion of 5G in the United States, the United States regulators wanted those satellite operators to surrender their right to use those frequencies so that it can be used to further their 5G expansion plans. Most of the satellites did agree with that. There was a very good compensation that was also provided. But what if tomorrow in some other country such requirement comes and then the satellite operators are unwilling to hand over their frequencies? The resultant situation would be that there is a potential interference that may be caused, because the satellites and the telecom operators, the terrestrial networks, will both be operating in somewhere very close frequencies. So how do we regulate such situations? Because frequency is a finite natural resource which has already been allotted and being coordinated by ITU. So how do we ensure that there is no interference with the terrestrial frequencies? At the same time, the space industry is also given the necessary bandwidth to operate and then further their operations. The most debated and burning issue since probably the last 3-4 decades is how to do justice to the less developed countries. Historically, the geostationary orbital slots were being utilized mostly by the developed countries. It was a first come first serve basis. So say United States had the necessary technology, they registered their satellites, they got orbital slots for a number of locations, not only over US, but also over certain other jurisdictions, including Africa. But if we go by the Outer Space Treaty, which as Justice Bhatt had very rightly said in his inaugural speech, that it talks about space being common to mankind, and it should be utilized to further the interests of mankind as a whole. So how do we ensure that the less developed countries who are currently in their initial stages of developing the necessary resources to become a spacefaring nation, or who are not yet having the necessary resources to even venture into space, so how do we protect their interests? Does ITU have the necessary safeguards in order to ensure that space remains a common heritage for the mankind? It is for common use of mankind. So we need to ensure that there is equity and equitable justice that is accorded to the less developed countries. That is the case of geostationary satellites. The recent problem which has emerged is the utilization of the low Earth orbit satellites, low Earth orbits. So as we know that there are plans to populate the low Earth orbit satellites, and probably 10,000 satellites would be in orbit in the next 5 years. Will there be enough space left in order to ensure that the countries which are now being left out in the space race will have space left in order to ensure that their satellites are also in orbit? Should we put a sort of quota for each country? Probably we can think of putting a quota based on the population which has to be catered. We need to also understand that though low Earth orbit is a very wide area, currently we have satellites probably separated by hundreds of kilometers, two satellites in the operating in the low Earth orbit. But if such steep addition of satellites keeps on continuing, then we will soon reach a stage where there would not be space left in order to put new satellites. So how are we going to cater to this problem which will emerge in the future? That is also something which needs to be pondered upon by the international community. So I have already covered this clogging in the low Earth orbit satellites, low Earth orbit. So how that clogging can be and should be stopped or curtailed in order to ensure that there is enough space left for other satellites to operate.
So Chinmoy, before you move forward,
Yeah.
you mentioned about orbital spaces and how developed countries have already occupied them.
Right.
Does it raise the issues of competition law? Like, are they getting dominant market position?
We may say that, but again, if we see the market, we have to define what is market. So like say at the time when the orbital slots were being distributed for the geostationary orbits, it was probably 4 decades ago. So what was the relevant market at that time? That also needs to be considered, and whether it will have extraterritorial jurisdiction. It's a very complex issue because we see American satellites operating over Africa. Can we say that it is a global competition issue? So that also we need to like ponder upon with how the territoriality.
And then we need to see who would be that global regulator.
Right. Very right. So the next part of my presentation, I would sum up the issues that are currently emerging in the remote sensing sector. So remote sensing is basically Earth observation. The satellites which carry out Earth observation, they do not deal with communication. So there may be a number of usage of Earth observation satellites, say disaster forecasting, or say agricultural imaging. The other usage may be related to security applications in order to find out what is the military buildup that is happening, how are foreign forces trying to move their troops. So there are a number of number of applications of remote sensing satellites. So these are the new issues that are coming up. The first issue is very relevant, and it is related to IPR. So what happens is that, say, today a software has been developed by a particular company by which they can process the data that is being downloaded from the satellite. So it is sort of a raw data. Technically, we call it L0 data. So there are a number of softwares which are developed by various companies, and they use it to further refine the data to get the product that they are wanting to use or wanting to sell. So the first layer that they make, we call it L1 data, and then further refinement. If further refinement happens, then we call it L2 data, and so on. So the basic issue that may arise is that, say, a company X has developed a software to develop L0 data to a certain product, L1 data. Now, that software is being used by some other company. Are we able to track that there is violation of IPR when the other finished good is other finished product is also derived from the same software? So are we able to look at such IPR issues? How do we tackle it if the satellite itself is equipped with the necessary hardware and software to directly process the data on board and then transmit to the ground station's L1 data? So we never know whether there is some software piracy that has happened, and then some satellite which is on board in outer space is utilizing the pirated software in order to deliver the data to its ground stations. Which country would have jurisdiction? If at all, that satellite which is on board, it has got the software to process the data there, because all the countries do not include in their territorial jurisdiction their space assets. So in that case, what would we say, whether it is a space asset of a particular country, or whether there should be an international regime which will regulate such satellites in the outer space? So that is one issue. The other issue that is coming up is the use of AI, artificial intelligence. Chat GPT has been doing a lot of rounds recently, and we have seen how useful can artificial intelligence be to process data. So in such a case where artificial intelligence is being used to process data, how do we give the appropriate ownership to the developer of the artificial intelligence software to process the data? And there are also concepts which are doing circles in the intellectual community, intellectual legal community, sorry, that we should also give ownership to artificial intelligence. We should recognize them as artificial persons. Should we do that? And will it be beneficial for the development of softwares which are needed for better refinement of remote sensing data? So how do we regulate the use of artificial intelligence utilized in remote sensing softwares? The other big issue is issue of export control. So as most of us are aware, there are export control laws for transfer of technical know-how from one jurisdiction to other. Every country has its own export control laws. Some laws are very robust, other laws are not. So the issue primarily with remote sensing softwares is that it is not a hardware which is physically crossing the borders. Say it is not, it is only a CD probably, or a pen drive which is crossing the borders from US to India when we are transacting in softwares. So how do we ensure that the export control laws of the particular country are not being bypassed? That pen drive, that CD, or it may even be a Google Drive file. So how do we ensure that the software prohibited under export control has not crossed the borders, because it is not a hardware? So these are also issues which are very relevant, because remote sensing has got a lot of security applications, and there are satellites which are in orbit which can even track movement of a particular person or a vehicle on Earth. So the spatial resolution, which is currently, to my knowledge, is 30 centimeters. So 30 centimeter resolution, they can track any movements in 30 centimeter resolution. So that's a very, very advanced imaging that and live video which can be got. So the other thing which is also concerning the use of low Earth orbits is that there are satellites which can fly in a lower Earth orbit when they have to image a particular location, and they can maneuver their satellite to a higher orbit. So how do we know that those satellites are not in violation of the national or international laws when they are sort of changing their orbit. Is that allowed? So remote sensing is going to be a burning issue. We have seen the use of remote sensing in the Ukraine war. The American satellites have been put into extensive use by Ukraine, and they are able to get the locations, and then they can fix their targets. So remote sensing, the export control and the software issues need to be sorted out so that it does not give rise to potential national disputes between sovereigns or between two private companies. So as I already covered, the cross-border Earth observation capabilities of remote sensing satellites also somewhere needs to be regulated, because we do regulate drones. A drone from Pakistan cannot fly into India and take imagery saying that I'm permitted to do so, because the airspace is very clearly defined. But to the contrary, it is not even clear as to what would be considered as outer space. There are the most popular concept is the Karaman line, which says that it would be somewhere close to 100 kilometers from where outer space starts. But there is no global consensus even on the onset of outer space, and the whether we should extend the air laws for territorial jurisdiction also to some part of LEO, because those satellites also have capabilities very similar to drones. So when we are not allowing drones, should laws be circumvented and satellites be put into orbit so as to do imaging which may even be better than the imaging that is done by drones? So how to regulate those issues is also something which the global space community has to think of and come up with a resolution. Now, coming to the issues related to liability of launch of satellites. So as is the current regulatory regime, the liability for launch of satellites is primarily on the sovereigns. So like if say a satellite is being built by the United States, then United States, even if it is a private satellite, any loss or damage caused due to that satellite, the United States would be responsible for that. The problem becomes more complex when, say, a satellite is manufactured in the US but launched by an Indian space rocket. So in that case, which country would be liable? Whether it would be the launching state, which is launching the satellites, or whether whether the launching state would be the satellite would be the jurisdiction where the satellite is originating from. So somewhere that dispute is sorted out. There is sort of a mutual agreement with which both the states can reach, and like what they can say is that, okay, when the satellite is on its course to reach outer space, so probably the state where the launch vehicle is situated, probably they can take the responsibility till that part. Now, once it is in orbit, probably the launching state would be the jurisdiction where that satellite is manufactured, or where the ownership of that satellite lies. That is one part of the problem. The other bigger part of this problem is that how do we ascertain the loss that can be caused due to a satellite, and how do we ensure that there is adequate security that such loss will be compensated? Now, all these satellites which are launched, most of the bigger satellite operators, they take insurance for their launch. There are some players, but that again is a is a market which is only having a few players, space insurance, only because of the fact that there is no particular valuation yardstick which can be put into use when calculating the loss that can be caused. Say, for example, a satellite may only be of 2 kgs, a small satellite, and it is put into orbit. And when it is in orbit, it is colliding with another satellite which is in its neighborhood. Now, there's a scientific theory that if such a collision happens, since it is vacuum, it will give rise to an endless reaction, which is called the Kessler's effect, Kessler's syndrome as well. So in that case, if one satellite collides with other, it will again collide with another satellite, and then it may cause a big mayhem in that particular orbit. And the cost of such a mayhem can be that that particular orbital spectrum, a wide orbital spectrum, would be unusable for centuries altogether. No satellite from Earth can be put in such orbit, because it is undergoing a chain reaction, and there are so much remains or remnants of those satellites making those rounds that they cannot put the satellites there. So in such a case, how do we calculate the liability on the first satellite which collided with the other satellite? So therefore, the insurance sector is also not growing as it is required in order to ensure that the satellite operators are being given the necessary security of from financial loss, and also it gives certain form of certainty to the sovereign nations that my loss, if at all it happens, it will be capped to this. So that again is something that we need to come up with, because the previously the population of satellites was probably in hundreds, but now it is in thousands, and it may be in multiples of 10,000s in the very recent times. So how do we come up with the valuation of liability which may be caused or which may be imposed on the launch state? The other issue which is also being which has been found to be in prevalence is jurisdiction shopping. So say I have to launch a satellite. So if I want to launch it from say Luxembourg, then Luxembourg will say that, okay, you need to give me security of only $10,000. So if it would be $10,000, then I would be like, I'm financially capable of, I being a satellite operator, I'm financially capable to give us security of $10,000. But in a stricter regime, say for example, the United States, if I want to launch a satellite from the United States, they may come up with the requirement of a security of $100,000. So I would prefer, being a commercial satellite operator, to launch my satellite from Luxembourg and not from the United States, so that I have to give a lesser amount of security. There are some extreme cases, like some island nations, which say that if you want to, if you put your ownership here, you don't even need to give any security. You can, we don't have any requirement of security. You can launch your satellite, and we will take the responsibility. But are those countries themselves capable to guarantee any loss that may be caused in space? Their GDP may not even be sufficient to cover up the loss that is potentially lying there if any mayhem happens in the outer space. So how do we come up with regulatory measures that there is some uniformity in terms of valuation of the potential liability, and there is no jurisdiction shopping that is done by commercial satellite operators? The other issue is debris creation. So like for example, if a rocket is carrying a satellite, once that satellite is launched, the upper part of that rocket keeps on moving in the orbit till where it reached. So it will also become it will be lying there in most of the cases for hundreds of years. It is defunct, it is of no use, but it is adding on to the debris that is there in the outer space. So how do we ensure that once a satellite is launched, the launch vehicle does not remain there? That is one part of the story. The second part is that I have a satellite which I'm putting it into orbit. Now, if there is a requirement of satellites being put there and having the requisite fuel or maneuvering capability in order to ensure that once their lifetime ends, they can maneuver themselves back to the atmosphere or to the graveyard orbits in the geostationary orbits, so that it does not cause clogging of the orbits and it does not lead to debris creation. There are no uniform requirements for such maneuvering and fuel requirements when a satellite is being launched. So do we need to ensure that there has to be a maneuvering regime, a maneuvering requirement for each satellite that is being operated? Me being a commercial operator, that will add on to my costs of building that satellite, and I'll not want to probably have maneuvering capability if it does not make a business sense for me. So how can I be compelled to have that capability? Recently, our government has done a really good job. Some of the launch vehicle upper stages which have been launching satellites recently, all of them are being used as platforms to carry payloads for startups, and those startups are using the upper stages to, and it is sort of a satellite which is used as a satellite, so that the startups which cannot afford to get a satellite, to build a satellite, they are given a platform where they can test their products. So that is also something that the global space industry needs to look into and resolve this problem. The other issue is space situational awareness. So like if a satellite is being launched, then it has to find out a particular slot of time where it can launch from a particular geographical location. We in India are very advanced in the in tracking the real-time location of satellites, and our launch vehicles, the Indian launch vehicles, when they get launched, we utilize our capabilities, and then we ensure that there is no satellite which is somewhere close to the vicinity of the trajectory of launch. But is there a uniform regime which every country can follow and should follow? Is there a mandatory requirement of space situational awareness being carried out before any launch takes place? And what should be the yardsticks for that? If whether we should ensure that no satellite should be in the vicinity in the in 1,000 kilometers in the outer space, or should we ensure that no satellites are there in radius of 100 kilometers? So there is no uniformity as to that, which also needs to be resolved. So the launch issue, the valuation of liability, that is somewhere stopping the global industry and the space ecosystem from realizing the benefits of satellites. So that certainty of liability calculation valuation needs to be urgently brought into play, so that the utilization of satellites can increase, and the commercial operators also get the necessary financial security to venture into the launch business. The other issue that I would be dealing with is space security. The first issue is the debris liability and removal, which is quite a burning issue. And there are a number of state and non-state players which are actively working on developing capabilities for debris removal. But there is no particular deadline for the global space ecosystem to come up with capabilities for debris removal. and that may also give rise to a particular friction for hindering the development of space and proper utilization of space. So there has to be some sort of urgent capability creation which needs to be done so as to ensure that uh, if whatever debris are accumulating, that is removed, because we have all seen those images of how the earth is being uh, increasingly clogged with satellite remains, and also with active satellites, and also with satellite remains, and the launch vehicle remains. So how do we tackle this problem? So that we need to urgently think of. The other issue relates to cyber security of satellites. Currently, there are capabilities that a satellite can be hacked from a ground station, and then the course of that satellite is changed. What if that hacking is done by a terrorist organization? They get into the pilot seat of a satellite, and then they intentionally collide it with some other satellite in its vicinity. That would give rise to the Kessler's syndrome, and it would do a global harm. So how do we ensure that all the satellites and their onboard computers are having a uniform, secure mechanism which will hinder any such hacking attempts? How do we ensure that? Are all the satellites up there having up-to-date systems, not having redundant softwares? Are all the ground stations which are communicating with those satellites having enough safeguards in their computers to ensure that no aliens can hack into their ground stations and then communicate with the satellite and give them commands? How do we ensure that this is taken care of? There are also cases where some satellites have approached their end of lifetime, and they are orbiting. They are probably more than 20 years. There are cases where some satellites which have aged more than 20 years, who are still in orbit, which are still in orbit, and they have sufficient power to communicate with the ground stations. So we can very well imagine that 2 decades back, it was the time of Windows XP, when those satellites which were launched 2 decades back are still running on Windows XP, and they have the capability to uplink and downlink from the Earth stations, they are very, very vulnerable to being intruded into, and then they maybe their course may be changed, or they may be there may be a number of things which may be done, and that may cause a global security collapse when it comes to utilization of outer space. The other issue relates to the space traffic management. Till now, it is projected that the low Earth orbits are capable of housing probably lakhs of satellites. But is there an authoritative mechanism to ensure that the low Earth orbits are only populated with the number of satellites which it can healthily handle? What if there is clogging happening, and then the distance between two satellites orbiting will reduce? So that increases the risk of collision. How do we ensure that space traffic management takes shape of a global regime, and then it is being handled at the global level, so as to ensure that there is no extra load on the orbits which are only meant for a number of satellites? So how do we ensure that there is no overload in the traffic in the low Earth orbit particularly, and also in the other orbits? The other issue is of unregistered satellites. As per the current requirements, there has to be a national registry that has to be maintained by every nation, which will contain the details of the satellites which they are putting into orbit. And they will also provide the information to the international registry, which is maintained by UNOSA. So there are cases wherein some spy satellites are put into orbit and purposefully they are not maintained in the national registry. And as a consequence, they also do not find a place in the international registry. If some accident happens in outer space and one of these satellites are the cause of it, how will even the international community be able to decisively point out that this satellite was launched by this country, because that satellite does not feature in any of the national registries? So how do we tackle with such problems and then find out that what are the ghost satellites which are doing their rounds in the orbit, and how do we ensure that such unregistered satellites are not allowed to be launched in the first place? So that also the global community needs to come up with some solution for that. The other issue is of ASATs, anti-satellite weapons. So we are also a country capable of anti-satellite weapons, ASATs. There are a number of other countries which are having the capability of ASATs. Is there a particular mechanism when ASATs can be used? When would it be deemed necessary to protect national sovereignty to utilize the ASATs? So what should be the safeguards for that? Because if any satellite is hit in the orbit, it may make that particular orbital broad spectrum unusable. So it would not only harm space assets of a particular country which is being attacked by the ASAT, but it is a harm which can be caused to the global mankind. So how do we ensure that there are mechanisms for utilization of ASATs? That also would may be a potential arena where we can see disputes between sovereigns and also between private and sovereign space operators. The other issue is of ICBMs. As we all know, this intercontinental ballistic missiles, their path also involves a certain amount of time being spent in outer space. So is there some regulation of the ICBMs getting into outer space and ensuring that these ICBMs are not causing any collision with any space assets out there? What if once an ICBM is launched, the other country which is trying to counter that attack also launches another ICBM or some attack missile, and they both collide in the space? So what if their debris will lead to debris creation, or if it is very unfortunate, what if it gives rise to the Kessler syndrome? So how do we tackle such problems which the Earth may see in the near future? The other issue relates to utilization of celestial resources. This is as the outer space so I'll start with this, that what is the concept of space mining first was voiced in a fictional novel in 1903, and since then it has inspired the scientific community to come up with solutions for space mining, and currently it is very much possible that space mining can happen. In fact, recently a space vehicle of JAXA came up with samples collected from an asteroid. So how do we so we have reached a space where space mining is possible. Now the question is whether that should be allowed. If allowed, how do we regulate that? So there have been some developments, and this is in 2015 the United States came up with this Commercial Space Launch Act, which says that the any person shall be entitled to any asteroid resource or space resource obtained, including to possess, own, transport, use, and sell the asteroid resource. So it is giving liability to its nationals or its corporate nationals to carry out activities of mining in outer space and give them ownership. But the question is that whether, and then it came up with the Artemis Accord, which again permits space mining. But the question is that whether it is permitted under the outer space law. So examining space mining under the outer space law, Article 2 says that there should not be any national appropriation by claim of sovereignty. But what would be the term? How would we define the term appropriation? Whether we would also include excavation, that the space resource is being appropriated by a particular space actor, or whether we would only ascribe the term appropriation when a person claims property rights over a particular space object. So how would we define appropriation? That is also something that the global community has to think of. The other issue and is the fundamental issue is that the definition of Article 1 in the Outer Space Treaty, it says that the use of outer space shall be carried out for the benefit and interest of all countries. Again, Article 55A of the United Nations Charter also says that the world will ensure that highest standards of living, full employment, and conditions for economic and social progress and development. The world is aspiring for that, and the global mankind would move in these directions. So probably we can draw a balance in favor of space mining, because it is being projected that rare earth minerals would be soon depleted, and we would be needing those rare earth minerals to carry out with manufacturing semiconductors and other usages. So we can probably strike a balance, saying that okay, it is outer space shall be used for the benefit of all countries and mankind. So if we allow space mining, probably it will give rise to the higher standards of living, full employment, and conditions of economic and social progress for the global community. So that may be one argument in support of outer space mining. The other issue which we need to deliberate is Article 31(1) of the Vienna Convention of Law of Treaties. It says that treaty shall be interpreted in good faith in accordance with ordinary meaning to be given to the terms of the treaty. So let us ascribe this interpretation of treaties to the Outer Space Treaty. So if we see that, then Article 1 and 2, if we do the cumulative reading, then we will see that the resources can be appropriated by states, subject to a qualification that the appropriation shall not be done in an isolated manner. That is, the resources must be shared on an equitable basis. But what can be an equitable basis? Will a private state actor, which has taken all the pain and technological investments to mine and bring something to the earth, will it want to share its the mineral in its possession with the poorer countries in the world? Will it want to give a share to the global community? Because it is his own efforts. So here again, it is in conflict with the sweat of brow doctrine, which is generally used in IPR, that if a person has put in his efforts, so therefore we give them IPR protection. So will this also be argued by the commercial space actors that no, we will not share it with the global community, it is our own property? So that also needs to be deliberated, and a middle path needs to be found out. So summing up, here are a few suggestions which may be utilized by the global community for its deliberations to come up with new policy development. So first of all, we should have specific dispute resolution mechanisms which are global in nature, not national in nature, because again, that may give rise to forum shopping. So how should a global space dispute resolution mechanism be formed? Till Now, there have not been a number of space disputes. Probably it is less than 40, the bigger space disputes. But it was the time when there are only a few hundred satellites in orbit, but now the times have changed. So there are many potential disputes which are brewing around the globe. So how can that be catered to? There are a number of working groups and discussions that are happening, but the global community needs to arrive at a consensus for a uniform dispute resolution mechanism for space industry. But when is that going to take shape and how much time is it going to take is something that we cannot comment on. The other suggestion would be to come up with new international instruments, as rightly said by our guest of honor, Dr. Subramaniam, and also by our chief guest, Justice Bhatt, that the treaties were formed at a time when only the space actors had the capability to venture into space. But now the times have changed. Even if the state actors in some underdeveloped countries are lacking this capability, the private actors in the same countries are investing and putting in the hard effort to acquire that capability. So is the current system capable to handle, or can the current treaty mechanisms or laws in place be interpreted in such a way that it can solve disputes which will involve commercial actors as well? We need to ponder upon this, and we need to come up with new instruments, international instruments, if the current regime is insufficient. The other, which is a problem with a pressing need for addressal, is a coordination mechanism for satellites in the low Earth orbit. As I stated earlier, it is getting populated in a very steep trajectory, and there has to be a mechanism as to how will the satellites be put into orbit, and what would be the extent of satellites that can be put into orbit, which again needs to be made into a uniform global regulatory mechanism. It cannot be done in silos by a country. That US may decide that, okay, today we will allow 10,000 satellites to be put into orbit, but at the same time, some country in the Europe, it says that no, we'll restrict our satellite numbers to 500. So how can a global mechanism be created in order to ensure that this orbits are not overcrowded in the first place? And the second most important part is that adequate security levels are maintained in the low Earth orbit, because currently there are capabilities that all the usages of geostationary satellites can be catered by satellites in the low Earth orbit, and they are cost efficient, they are easy to launch, and they also have a small lifespan. So the investment is also less, and it can be replaced with new modified technologies. So how do we come up with a coordination mechanism for all problems related to low Earth orbit, including downlinking and uplinking frequencies? The other issue is that the national laws are not in sync currently across the globe. Some countries have very robust national laws, but at the same time, there are also jurisdictions which have no laws related to space in their national laws. So how do we ensure that there is a global regime for national law formation? And whether the United Nations Office of Outer Space Affairs should take the lead to come up with mandatory mechanisms which need to be followed by every country which is venturing into space. So should we come up with such solutions? Because if we don't act fast as a global community, we may be staring at a potential disaster which will have an impact on each one of us. The other issue is equitable distribution of resources. As I said, some states are more capable, the others are less capable. How do we ensure that the equitable distribution of space is accorded to all the countries, so that no one is left out in this space development that the mankind is witnessing in the current times. This is again a fictional issue as of now, but there are claims that companies like SpaceX would venture into Mars and they would form colonies there. There are also claims that if a private company is able to go to Mars, it is not obliged to obey the rules of currently existing in Earth for outer space, and they can even acquire property there because they are the first ones who are in fact first venturing there. So they can do anything with those celestial resources. Should we allow that, or should we not allow that? Because there are benefits of allowing such extraterrestrial ownership for distant planets, because then it will act as the initiative for private players to take that risk and make that investment to venture into distant planets in search of minerals. It will ultimately be beneficial for mankind if such technological developments take place. But ownership is also a contentious issue. So that also the global community has to come up with some solution as to either grant or reject the concept of extraterrestrial ownership for distant planets. So that is, with that, I'll sum up my presentation. Thank you all for a patient listening, and thanks again to the organizers for giving me this opportunity to share my thoughts about the emerging disputes in the space sector. Thank you.
Thank you so much, Chinmoy, for such an exhaustive and well-structured presentation. We personally learned a lot and liked the presentation. There's a question by Anant Yadav. He asks, in future, satellites are going to increase in numbers. Whether there's any authority taking care of environmental aspects while regulating the activities.
So yes, this is a very good question. There have been deliberations that are ongoing. Now, if we see the environmental aspects, it has got several subparts into it. Whether we would consider the outer space environment also under the definition of environment, or whether we would only consider the Earth environment. So if we should probably give it a broader ambit, and outer space should also be included into it. But coming to the answer, there is to my mind, there is no binding regulation as of now to ensure that there is environmental protection that is happening. But again, for the Earth's atmosphere, we have a number of laws. We can even use our environmental acts for any contamination that happens by space objects. There has been a case where there was some nuclear spillage over Canada by a satellite, and they ultimately resolved it by diplomatic means, but they could have utilized also put to use their national laws in Canada to answer that. But when it comes to outer space, there is no binding mechanism as of now.
Thank you for that. And same person asks a question about if you know about an incident wherein there is a collision of satellite in orbit.
Yes, it has happened in the past, but again, that had not given rise to widespread damages, and it was way back, probably in the 1980s or so. At that time, there was no clogging of satellites in the LEO. Probably we had no satellites in the LEO at that time.
Right. Thank you so much, Chinmoy.
My pleasure. My pleasure.
Now,
thank you. Thank you, everyone.
Presentation.
I thank Mr. Chinmay Roy for giving us a basic understanding of space law and satellite and their different aspects. I now invite the second speaker, Mr. Arthat Kurlekar. Mr. Kurlekar is an associate in the International Arbitration Group with a practice that focuses on representing states and state-owned entities in complex investor-state arbitrations international commercial arbitrations, and public international law matters. Mr. Kodlekar has experience in investment and international commercial arbitration proceedings under the rules of IC, SID, UNC, UNCITRAL, and the ICC as whole. He has also experience in international trade disputes before the WTO. His areas of focus include PIL issues, international trade, law of seas, law of international organizations, and international sanctions. The floor is all yours, sir.
Thank you so much. Just allow me to share my screen.
And Chinmoy, there's one question for you in the question and answer, which you can answer by comment. Well,
Sure, Arthad. Sure.
Okay.
Sorry to interrupt for a moment. I would just like to share one instance. Arthad has been probably one of the first from our country to have suggested a mechanism for resolution of space disputes. So he was still a student in NUJS. While doing my research, I came to know of his paper. He published it way back in 2006, wherein he came up with a mechanism as to how such disputes can be resolved. And they are becoming increasingly important, considering the increasing use of space in the current times.
it was through that paper I learned about him.
Okay, great.
Thank you. Am I audible?
Yeah. Can you put your
Okay.
PPT presentation mode, Arthad?
Um,
On the bottom right, just next to the Zoom option, there's a presentation mode.
Just show presenter view. Is that it?
You can try pressing that. It will be better than this. Or on the top left from beginning, if you press from beginning, top left,
Hold on.
that will also put it
Okay.
in the presentation mode. Yeah.
Okay. Is that better?
Third, what I would suggest is if you click in a normal way when we make presentations in the bottom right corner where there's that slide view. So
Okay,
probably
I can try.
that will solve the problem. Or like
Is it working?
you can press on set slideshow in the top ribbon.
Okay.
Fourth item there, setup slideshow.
Hold
No,
on.
sorry, from the beginning, if you do, from the beginning, if you click on that.
Yeah,
yes.
I tried that. Hold on a second.
Right.
I'm gonna just stop sharing and reshare. Perhaps that will help.
Yes.
Sorry for the technological glitches.
No, it is better.
Is that better?
This is perfect. Thank you.
Okay. Wonderful. So let me start by thanking the organizers of Sorry, I think my slides failed. Chirag, can we pause for a second? I'll send you my presentation. Can you share that? I think that might be easier.
Yes, sir, you can send it across. I'll be sharing it so that Chirag sir can moderate the session also. Send it to Chirag sir. He can
Okay.
send it to me. I'll share it.
Okay, just give me 1 second and I'll
Yes, sir.
send
Yes,
it
sir.
across.
We'll wait, sir.
Thank you. Okay, I've shared my PPT, but maybe why don't I begin while it is being shared. So thank you very much for the opportunity. It's a pleasure being here. We've heard from Chinmay a number of interesting points, particularly with respect to the different kinds of dispute that arise. And he spoke about registration, he spoke about the Kessler effect, ITU issues, and collisions. And then he asked a very relevant question: how should a global dispute resolution mechanism be formed? And which sort of goes to the topic of my presentation today. I think one of the ways to look at this is by surveying the interstate mechanisms which are currently available under the frameworks, and that would at least be useful guidance in deciding what sort of mechanism does the space industry want, or whether we look at bottom-up type of modes or whether we look at top-down type of modes. So the first issue which then arises, and as soon as the presentation is available, it would be helpful if it were
It
put
will
up.
just
But
take
the
a
first,
minute, Arthad.
yeah, no worries. So the first issue which arises is what is really the connection between nationals and their states, and why do the constitutive treaties in the mechanism that they provide. So the liability convention, we'll come to that in a second, but it provides for a specific mechanism for dispute resolution. So why do these dispute resolution mechanisms, which talk about interstate issues, and do that, and how do they relate to private actions? And so let's take a step back and start from that. So the mechanism through which this happens is known as diplomatic espousal. And the landmark case for that is the Mauromatis case. It's a very old case where the Permanent Court of International Justice held it is an elementary principle. Now I'm quoting: it is an elementary principle of international law that a state is entitled to protect its subjects. Here you go. Wonderful.
Sir, you can tell us whenever you want us to move ahead in the PPT. So we'll just move to the next slide.
Okay, can you move to slide 2, please?
Yeah, okay, sir.
Right. So I was talking about the Mauromatis case and the quote, which says it is an elementary principle of international law that a state is entitled to protect its subjects when injured by acts contrary to international law committed by another state. Now, the PCIJ, therefore, the Permanent Court of International Justice, supported the idea that an injury to the national is an injury to the state. And this has later been termed as the Mauromatis fiction. If we move to the next slide, please. Yes, here, perfect. So the Mauromatis formulation of the principle of diplomatic protection has also been used in subsequent cases. Now, in a paper which was strikingly called as the second death of Euripide Mauromatis, Professor Pele, who's a world-renowned authority on international law, he sketches out how there has been a move away from the Mauromatis fiction, but highlighting that the essence of the notion that a state can bring a claim against another state on behalf of its national still continues to apply. In the space law context, a similar position is seen in the primary rules established by the constitutive treaties. So Article 8.1 of the Liability Convention says, and I quote, a state which suffers damage or whose nationals suffers damage may present a claim. And here, by providing a clear primary rule of international law, the difficulties which arise in diplomatic espousal under customary international law are mitigated, if not circumvented. But nevertheless, the exercise of espousal remains a matter of discretion. This is also a fairly well-established principle that a national may not have a right under international law to require their state to bring a claim. So, assuming that a state does bring a claim, the next question arises, against whom can a claim be brought? Now, Article 6 of the Outer Space Treaty provides a sort of a way up. So Mauramatis is a fiction where a state is espousing the claim, and Article 6 of the Outer Space Treaty works in the other direction. It says state parties shall bear responsibility for the national activities in outer space and for assuring that national activities are carried out in conformity with the provisions of the Outer Space Treaty. So the constitutive treaties thus present a framework where liability can be determined for actions of the national state causing damage to the nationals of another state. Now, while there are complexities relating to jurisdiction, identification of who exactly is a national, the mere possibility that an entirely private dispute for subject matter governed by the treaties can put it, by private, I mean between nationals of two different states, not by the subject matter of it, but basically a dispute governed by two nationals or a dispute between two nationals governed by the treaties can potentially be elevated to an interstate level. And that is remarkable. And I believe that warrants a closer analysis of the mechanisms which exist. Can we move to the next slide, please? Thank you. So let's look at the different forums which and instruments that we will cover. So one of the most prominent conventions, and I referred to this earlier, is the Liability Convention, which provides for a specific mode of dispute resolution. And uniquely, it also provides for specific rules of attribution of liability, which I will just touch upon. I know that Mr. Chaisema will focus in detail in the next presentation on issues of liability, but just maybe an introductory bit and some interesting ideas on that. The second agreed note here would be the International Telecommunications Union's dispute resolution provisions. And the ITU, Chinmay referred to the ITU a lot in his prior presentation, so it needs no further introduction, just to say that it's an international organization with functions relating to discharge of space-related resources and basically what sort of resources. So Chinmay touched upon that, orbital allocations, radio frequencies, and so on. The third possible mode is the International Court of Justice. Now, there was a recent case where a unique argument was proffered, which asked the court whether under Article 2.3 of the UN Charter, the court could assume jurisdiction. The court declined, saying that Article 2.3 was, in a sense, just general obligation, which did not confer upon the court any specific jurisdiction. The fourth method, which I'll touch upon, is interstate arbitration, and more specifically under the PCA optional rules of arbitration. And at the cost of sounding too presumptuous, I leave it to other panelists to discuss private commercial arbitration or arbitration between an individual and a state, whether it be through already established means, like for instance, investment arbitration, or through different mechanisms potentially allowing individual standing to bring a claim against a state. My presentation will focus only on interstate arbitration. And finally, I will attempt to take you through certain parts of a suggestion, the ILA Draft Convention on the Settlement of Space Disputes. The Draft Convention is a product of the International Law Association, who proposed a mechanism similar to the dispute settlement mechanism under the Law of the Sea Convention. Now, theoretically, there may be overlaps with other frameworks as well. So potentially an overlap with the WTO framework or the Law of the Sea Convention framework itself. But given the time constraints of this presentation, I will limit this to only those mechanisms under which a direct claim for breach of space-related obligations may be brought, as opposed to incidental or implicated claims to those obligations under other frameworks. And I'm happy to answer questions on those other frameworks, but my focus will be only where direct claims can be brought. Can we move to the next slide, please? So let's look at the Liability Convention, and I invite you to consider the two basic rules and the dispute settlement mechanisms under the Liability Conventions. Now, I won't delve too much into the details of each of those rules, but primarily where there is damage to the surface of the Earth, the rule of absolute liability is applied. which most of you, if not all, would be familiar with. And where there is damage to, well, outside the surface of the earth, the rule of fault-based liability is applied, where causation and damage has to be then established. So those are the two primary rules. If we move, can we move to the next slide, please? Now, in a fault-based scenario, there may be issues of causation. Can we move to the next slide? Slide 5, please. Yes, thank you. Now, given the issues of causation that may arise, because it's difficult to establish fault, in 2015, the UN Committee on Peaceful Uses of Outer Space asked a very interesting question. I've put in the quote on the slide, but in effect, the question was whether non-adherence to soft law instruments constituted fault. Now, there are two ways of looking at this. One way is to say that, and this is a quote from the International Court of Justice, who said, refusal to fulfill a treaty obligation must involves international responsibility. Now, what treaty obligation are we talking about in case of soft law instruments? Well, an argument can be made that Article 9 of the Outer Space Treaty provides for the obligation to cooperate and provide mutual assistance. One may argue that it is this obligation which is breached if you breach soft law requirements. These soft law requirements typically are some sort of best practices or adopted by the United Nations General Assembly, or have some force into different practices or relating to space. And so one wonders if those aren't followed, is a state which is in non-compliance with these General Assembly resolutions, is such a state really cooperating with other states? On the other hand, as you may wonder, those General Assembly resolutions are not in themselves binding. And in any case, to establish liability under the Liability Convention, both Article 3 and 4, which are then rules of liability, require damage to be proven. And so without damage, one could potentially not see liability under the Liability Convention. Now, more than this, I don't want to impinge on this issue, and I'll let Mr. Chesima inform us more on this topic. And I'll move on to the dispute resolution framework specifically under the Liability Convention. Can we move to the next slide, please? Thank you. So within the framework of these rules, which I just described, the Liability Convention provides for a dispute resolution option. So Article 9 provides for a multi-tiered process. So this provides that a state is entitled to pursue compensation against another, well, a launching state, through diplomatic channels. Now, in a sense, there are other rules which provide for specific procedures, but if diplomatic channels fail, then Article 14 provides for a claims commission to be established. And the features of the Claims Commission demonstrate a far-thinking nature of the drafters of the Liability Convention. Now, arbitration practitioners among those in the audience may recognize some of the features here. For instance, a default appointment mechanism of one person ensures that the commission cannot be scuttled by non-cooperation. Take, for example, the second advisory opinion of the International Court of Justice in the interpretation of peace treaties case. There, the court was asked a question to decide on an issue of dispute settlement procedure under the peace treaties of 1947 between Bulgaria, Hungary, Romania on the one side, and allied states on the other. Now, before this second advisory opinion, there was a previous one. And the previous one concerned the binding nature of this arbitration mechanism under the peace treaties. Now, the court had held there that arbitration as a mode of dispute resolution was binding. Notwithstanding this, Bulgaria, Romania, and Hungary declined to appoint their party-appointed arbitrator within a time limit. The allied states wanted to have the arbitration tribunal constituted. And so they wondered whether under the peace treaties, the Secretary General of the UN, who was empowered to appoint the third arbitrator, could also appoint the second arbitrator. The court declined, stating that the treaty specifically empowered the UN Secretary General to appoint only one arbitrator, and therefore this would mean an arbitration tribunal of only two arbitrators, which was not foreseen in the treaties. And so the treaties did not basically create any sort of default way in which a tribunal could be constituted. So potentially, even though Bulgaria, Romania, and Hungary were in breach of their obligation to appoint an arbitrator, the clause itself could not be enforced because the tribunal failed to constitute. By addressing this issue, by creating this default mechanism where one member of where in case of default, one member will be appointed, the Claims Commission presents an effective way. Similarly, these issues are far-reaching in that the Claims Commission also addresses issues of joint and several liability. So specific to space issues or space law-related issues, it specifically it incorporates features relating to space or space law issues. Can we move to the next slide, please? Now, apart from the liability convention, I'm sure those of you actively engaged in the field, like Chinmay, for example, know of the importance of the International Telecommunications Union. Now, this, I believe, as I agree with Chinmay, that this deserves significantly more attention than what has been given. And as a step towards that, perhaps I think it's useful to discuss the kind of disputes that may arise within the ITU framework and what mode of dispute resolutions are possible under the ITU. Can we move to the next slide, please? So the Constitution, Convention, and administrative regulations, and particularly the radio regulations governing space communications of the ITU, regulate the use of radio frequencies and geostationary orbital positions. In his speech, Chinmay referred to a very important term in this context, which is harmful interference, and we'll come to that in a second. So within the ITU framework, all states are free to choose and assign particular radio frequencies and orbital positions to their satellites, though they're obliged to avoid harmful interference. Now, this rule is important as it protects states who have registered with the ITU from interference from latecomers. So this obligation, for instance, is similar to the due regard obligations which states have typically, which apply to commons. Due regard provisions or issues relating to harmful interference, though, may, among other issues, result in a number of disputes, particularly because there are competing interests of states involved. Next slide, please. So the dispute resolution under the ITU agreement is dealt with by Article 56 of the Constitution of the ITU. Article 56 states that member states may settle their disputes on questions relating to the interpretation or application of the convention, or among the of the convention, of the administrative regulations and the radio regulations, etc., by negotiation, diplomatic channels, or procedures established by bilateral or multilateral treaties concluded between the states involved. Now, if none of these methods of settlements are adopted, then there is a default recourse to arbitration in accordance with the other provisions of the ITU convention. Now, member states of the ITU have also concluded an optional protocol, it should read optional protocol, on the compulsory settlement of disputes relating to the Constitution. This optional protocol basically does away with the caveat, or does away with this exclusion, opt-out, essentially making arbitration a compulsory mode of dispute resolution. And among the ITU states, 64 states to date have signed on to this optional protocol. Now, unlike the liability convention, the attributes of the arbitration clause in the ITU Constitution sort of reflect an understanding which does not accurately capture all contemporaneous developments. So for instance, the arbitration clause allows for an arbitration to be conducted by another government. And it's not something which typically you see in interstate disputes these days. But as a party-driven process, states are under full liberty to agree to certain modernizations, let's say, in case of disputes. But definitely the arbitration clause or its drafting within the ITU dispute resolution can be tightened and needs a relook. Now, I mentioned as an example that governments can conduct an arbitration, but it's not the only way. So the ITU dispute resolution clause actually provides for several options from which parties can choose. But by doing so, it presents a fairly convoluted picture of how the arbitral process would work. And so parties could choose to agree to a simpler process potentially, which, as I said, I think it warrants a second look. So a second aspect, and this is just noting attributes of the dispute resolution clause, is the parallels these provisions have to the Law of the Sea Convention. The negotiations of the Law of the Sea Convention ended around 10 years prior to the Constitution and Convention of the ITU, and it seems to have had some influence. Now, I haven't really had a chance to examine the travaux of the Constitution of the ITU, but the similarities between the provisions are quite striking. So Articles 281 and 282 of the Law of the Sea Convention bear resemblance to this initial part of Article 56, which allows for other means of dispute settlement. And therefore, this idea that arbitration will be a default mechanism, and if states agree to something else, then that would be a preferred mode of arbitration, is a similar formula to that of the Law of the Sea Convention. Now, as I mentioned, the optional protocol sort of changes that assumption, but not all states are party to the optional protocol. Next slide, please. Now, within the ITU framework, Chinmay mentioned that there may be issues with respect to harmful interference. The question arises are there any overlaps between the subject matter of what may be governed by the Liability Convention and what may be governed by specific rules of the ITU Convention? And in case that there is some sort of damage through harmful interference, there could be an overlap between the two frameworks. Now, there could also be an issue of overlap between these obligations and certain WTO frameworks or market regulation related issues. Now, why is it relevant? Why is an overlap relevant? It's because that the ITU framework has certain jurisdictional limitations, and it appears that for these issues, the only binding mechanism available is a default mechanism. Now, the Liability Convention, it's a feature which I should probably highlight. The recommendations of the Liability Convention are not necessarily binding on the states. The states have to choose for those recommendations to be binding. And so if there is in fact overlap between the Liability Convention and the ITU, then potentially the dispute resolution mechanism under the Liability Convention could be preferred, and a default arbitration mechanism would not necessarily yield the result. On the other hand, it is also conceivable to argue that the ITU Convention itself forms a sort of lex specialis, and these are totally open questions. Next slide, please. When looking at interstate dispute resolutions forums, now obviously we have to look at the International Court of Justice. Many are familiar with the way in which it works, so I won't dwell too much upon it, but states can choose to have an optional clause declaration accepting the jurisdiction of the court. Most states have a qualified sort of jurisdiction. Typically, spacefaring nations either have no optional clause declarations or have a qualified declaration such that bringing a dispute seems a difficult threshold to overcome. There are other ways in which jurisdiction can be agreed if states so choose. So a compromise, which is a special agreement to refer a dispute, is one way. A compromissory clause is in another treaty or international instrument, which may be agreed in the future, is another way. But currently, that it doesn't appear to me, at least, that there are any references to the ICJ jurisdiction within the space law treaties. Can we move to the next slide, please? Thank you. So while the forum here, in case of the PCA optional rules, is interstate arbitration, the optional rules themselves alleviate some of the areas of friction between conventional arbitration and the particularities of outer space law. Now, these rules were passed, in fact, in 2012 by the Administrative Council of the PCA, and they are, in fact, far-reaching. So fundamentally, they are based on the UNCITRAL arbitration rules, but they have three main changes. The first is an express waiver of jurisdictional immunity. So when parties agree to arbitration, or when states agree to arbitration, there's an express waiver of jurisdictional immunity. That is, let's say, that is a clarification of an issue where majority would still agree that entering into an arbitration agreement is in fact a waiver. The second change is ensuring more stringent rules of confidentiality, and this is of significant importance. So Article 17.6 provides for an enunciated procedure where a party can choose to qualify certain documents as classified. The tribunal then can also decide who these classified documents can be released to and on what conditions. So especially in case of space issues where you have issues of trade secrets or company secrets involved, it is of vital relevance that broad provisions of confidentiality are issued in any dispute resolution mechanism that applies. The third and perhaps the most important feature of these rules is the treatment of technical and scientific experts. The PCA rules allow for a tribunal to appoint an expert subject to stringent rules of confidentiality. And they also envisage a possibility for the tribunal to jointly or separately provide a non-technical document summarizing and explaining the background to any technical issues that the parties may face. So this is the way in which the PCA rules try to address the fact that space disputes are technical, are complicated, and may not always be part of the expertise of the entire tribunal. But again, this is not the only solution out there. Within arbitration itself and drawing from other industries, parties have similar other options. For instance, drawing from construction arbitration, there are times when parties refer to a dispute to a non-binding dispute adjudication board or ask an engineer for their opinion as a first step. And in case the parties continue to disagree, then they refer a dispute to arbitration as a second step. Such mechanisms are also not unprecedented in interstate arbitration, where technical treaties can require a technical determination as a first step. Now, another option is where treaties often adopt specific procedures in case of technical dispute. And the best example of this is Annex 8 of the Law of the Sea Convention, which provides for special arbitration in case of disputes involving fisheries, marine environment, marine pollution, which again are technical disputes requiring significant scientific expertise. Now, within commentators, other suggestions which have been made recently include creation of an international organization, for instance, something similar to the World Intellectual Property Organization, which administers arbitration relating to intellectual property disputes. Now, what value would a specialized arbitration institute add that specialized rules or a roster of expert arbitrators cannot, remains an open question. So it would also depend on the kind of powers that are vested with such an institution and so on. Now, moving on to the next slide, please. Next slide, please.
Just give me a second, sir.
Sure.
Sir, you can go ahead. We'll just figure this out, sir.
Sure, no worries. So now we move to what I would call suggested mechanisms. And if you have noticed, I believe outer space law has many parallels to the law of the sea. And although no binding dispute resolution mechanisms have been agreed under the 5 constitutive treaties, perhaps inspired by the Law of the Sea Convention, the International Law Association prepared a draft convention on the settlement of disputes. Yeah, that's fine. That's fine. Thank you. So it is important to see here, before we go on to see the provisions, it's important to see the scope of the draft convention, which specifically covers activities by the nationals. And so to remind you of what I said earlier in the presentation, outer space law at least appears to permit a state to bring a claim on behalf of its nationals for damage caused by the nationals of another state. The draft convention seems to embrace this full scope of activities. Next slide, please. Now, looking at what modes are presented, the draft convention presents 2 non-binding mechanisms: exchange of views, and if the parties agree, then conciliation. And then it envisages that parties have a choice of forum between the International Court of Justice. I suppose what the ILA imagined would be a newly constituted international tribunal for space law and interstate arbitration. So this was the framework which the ILA sought. Can we move to the next slide, please? And the parallels between this and the Law of the Sea Convention are for everybody to see. So I've just, to compare, I have just put out some of the relevant obligations in the dispute resolution provisions of the Law of the Sea Treaty on the left hand, and the certain provisions of the ILA draft convention on the right hand. And as you can see, exchange of views, conciliation, application of certain procedures, and choice of procedures, the choice of forum between a court, the ICJ, and interstate arbitration seems to be the same formula which the ILA drafters sought was appropriate. And in a sense, they thought having parallels to, so because there are certain parallels in the substantive law between the Law of the Sea Convention and outer space law, they thought maybe dispute resolution would also work adequately in a similar manner. Can we move to the next slide? Right. So given the evolving nature of outer space law and space law related dispute resolution, I would like to conclude with this question. So should dispute resolution processes engage private space actors more? Many operations between private space actors are regulated by contract, and yet tortious claims committed by non-contracting parties may seemingly not fall within contractual stipulations. Similarly, allowing a person to sue a state may also have certain limitations, which I'm sure we will hear from other speakers, but suffice it to mention that in a potentially multi-state operation, which state should bear the brunt of a claim and what instruments would apply remain controversial questions. And in that spirit, one has to ask how modernizing, as Chinmay asked, how modernizing a global dispute resolution mechanism would work. So how do we look at this issue at an interstate level? And do we, if at all, need to look at this issue from a contractual and potentially also a individual to a state level? Yes, thank you. I conclude with this question. Please let me know if there are any questions.
You're muted, Chiro. Ah, there you go.
I can't see question in the chat box, but I really found your presentation to be very nicely structured. So thank you, Arthat, for that. You have systematically put all the points So, dear participants, if you have any questions, you can put it in the chat box very quickly. And I also take this opportunity to welcome Professor Dunk, Ms. Laura Jelinski, Shreyas.
Thank you for that. Hi from Philadelphia, United States.
Thanks, Chirag.
Yes. Can we have a group picture if there are no questions to be asked? Can I request all the panelists of this session to turn on their camera? Kiran ma'am, if you can also join us for a moment. Excellent. Just keep yourself in the center. Yeah.
Chirag, we also probably have Subramaniam sir there. Don't know if he's available.
Yes.
Probably he's not there.
Subramaniam sir, are you still connected with us?
Probably he's not there.
I think he might be listening. Yeah. Give me a second. So please give a pause. 1, 2, 3. Here it is. Thank you.
Thank you,
So,
Chirag sir.
thank you. Can we move to the next panelist?
Thank you very much for that insightful address, Arthat sir. Next, we have Mr. Shreyas Jayasimha. Sir is a mediator at Arna Law LLP India, and he has completed his BA LLB from NLSIU Bangalore and LLM from University of Warwick. He's expert in dispute resolution, including mediation, international and domestic arbitration, and litigation in civil and commercial law, company law, technology law, constitutional law, private international law, and law relating to foreign trade, intellectual property, aviation law, public law, and environmental law. Thank you very much, sir, for being with us today. Looking forward for your address. The platform is yours.
Namaste, all. Greetings to every part of the world.
Welcome.
Thank you very much. Thank you, Professor Chirag Balyan, for having me. Hello, Chinmoy. Thank you very much for your address, Arthad. I found that very insightful. And greetings to fellow panelists and the audience. So I must thank the internet for confirming my status as a anachronistic, perhaps dinosaur, which is professionally speaking. The time in which I started practicing internationally while continuing to be based in India, basically we did everything that we could get our hands on. That generation of us began practice in the early 2000s. And therefore, you have this embarrassing litany of areas that we've been exposed to. And then some of the fellow panelists and the listeners may be wondering what such a generalist is doing here amongst you. Having said that, Chinmoy will perhaps attest to some experience that I've had in this field for some time. And also, I'm grateful to have been accommodated in the earlier panel, but though my time could not, schedule could not permit it, in aviation. And I want to draw the link somewhat amusingly to say that perhaps the closest thing that comes to rocket science is jet engineering. And so I had the privilege of being trained in aspects of jet engineering to be able to deal with some of the disputes I had to deal with. And that had always piqued my interest, and my interest in space law was based on my immediate neighborhood, because the house I grew up in was a stone's throw away from ISRO headquarters. So I've always seen the national flag flying right there. But coming straight into the heart of the matter, and perhaps taking off where Arthad left us, the similarities between these domains. The one thing that a view of a generalist does is that it allows you to see patterns from one area to another. Arthad, you spoke about the similarity between law of the sea and law of space. But as I begin my address to you, I would also like you to consider whether there is such similarity with, let's say, nuclear law and space law. I have in mind the element of cataclysmic and catastrophic events, which nuclear law is very alive and present to. But the space regime, when the space law regime began, the internet didn't exist. The internet had no existence in the 60s, the 70s, and certainly not the time in which the ITU was being contemplated. And yet, perhaps the most significant and immediate contemporary catastrophe that we can imagine is perhaps the unavailability of the internet use through space assets. And so, be it the use of anti-satellite missiles, or be it the use of other jamming techniques, taking out the internet from our lives is perhaps involving space law more than any other. And so, the element of catastrophe that is that this domain has to now deal with is, I would say, similar. For example, I was at the International Nuclear Law Association meeting in Washington, D.C. earlier this year. And one of the points that was raised is that many of these conventions were drawn at a time in which the contemporary technologies that we are now familiar with were not in existence. And the contemporary form of geopolitics that is contended beyond states was also not in full contemplation. So, for example, in the nuclear regime, you have a situation where there's an armed conflict in the immediate vicinity of a nuclear facility. Now, where does liability lie? Between the person who constructed, the state that constructed the facility, the state that is actually in close proximity to it, the state that is exercising de facto control over areas, and similar questions can be contemplated when it comes to space, and which is why you have had attempts such as the McGill University attempt, which I will be referring to in the latter part of my presentation, to look at the peaceful use of outer space at all times. With that, I will seek the permission of the administrators to share my screen and get right into the PPT that is available. I want to thank my colleague Bhavya, who's helped along with Jay Mehta, my other colleague who's helped on this presentation. I hope my presentation is visible. Chirag, is it visible?
Yes, sir. It is visible, sir.
Okay, thank you. Thank you, Chinmay. Let me. Okay. Yes. So, and also, I want to make the point that I think as as the talent from the East continues to speak to talent from the West, whether it is in the avatar of Arthad, who's schooled here but was working elsewhere, or is in the form of Chinmoy, who's working in the in-house with institutions which have a global presence, but which have otherwise an Asian foundation, or whether it is some of us who are practicing internationally, irrespective of location, but while being based in Asia, there is a certain change in the texture of conversation in international law that we can perceive. The focus is looking at the liability convention to say that this applies clearly to states that launch or procure the launch, or from whose territory the space object is launched, and with whose facilities the space object is launched. Now, that itself is an important point to ponder, because the idea of launch is not limited to one state alone. To those of us who have viewed launch of a satellite, it's one of the most awesome experiences, perhaps only overtaken by witnessing the return of a vehicle within a few minutes after having the payload having been dispatched to the appropriate orbit, then to come back. And if you now look at the Artemis program, if you look at the public-private collaborations that are taking place in the United States and indeed in many other parts of the world, you will see a mosaic of collaboration, not just between states, but also between several private enterprises. And again, even if it's a private enterprise, ultimately, what state is that private enterprise most closely associated with? What are the tests to determine that proximity in law, and what consequence it would have in the extent, liability, and legal regime are also questions that will undoubtedly emerge as the pace of collaboration intensifies across boundaries. You will recall that one of the first projects that happened after the end of the Second World War was the construction, was the creation of International Aero Engines, a conglomerate that was to source parts from not just the United States and parts of Europe, but elements of collaboration from Germany or even Japan. And so collaboration by design was sought to be a foundation for peace. And again, even at the height of the conflicts that we've seen in the Cold War, at least in the realm of space, we've seen extraordinary levels of cooperation that has allowed us to even create the International Space Station. And the element of close, peaceful cooperation to achieve long-term goals of humanity is a heritage and a legacy that this and future generations must treasure. And any attempt to revise or review the foundations of the legal regimes must undoubtedly prioritize these long-term objectives of humanity. The liability convention itself is one part looking at jurisdiction, which is territorial, the other which looks at personal jurisdiction, territorial being linked to the space from which the object is launched, and personal where there is an element of control over the incorporated company and a company headquartered in their territory. And this jurisdiction, as the lawyers in this room will immediately recognize, is going to be a point of tremendous debate. Now, in either work from home, work from anywhere, what are the dotted line and straight line reporting structures? We've had some of the tech MNCs, CEOs being located in India for a while. They may be conducting the board meetings online. And so you have a multiple set of factual and legal developments that have happened since 1972, which is the time of the convention. And so attempts to, in 2023, interpret what and how and personal jurisdiction should look like in a time of work from anywhere, where the board itself may not be composed of individuals who are located in a particular place. From an entirely different sector, look at how FTX was organized, though it's within the cryptocurrency space. But if you look at there were about, in the insolvency filings, we see about 130 subsidiaries or related and group companies, and several jurisdictions, including, I recall seeing companies located in Senegal. Now, as the space sector, which was earlier almost entirely state dominated, increasingly meets and works with the private capital world, which is looking at investor state protection, which is looking at double tax avoidance protection, and private capital is quite used to and has many decades of experience of protecting itself from adverse state action, looking at a group of companies, and different legal regimes have had to tackle them. For example, in the insolvency space, a test that is developed in the Center for Main Interest. And so, which is why, going back to the FTX example, although the companies initially were located incorporated in Bahamas, when the insolvency occurs, it was all conducted in the United States. So here again, to what extent, what would an insolvency, for example, of a space company, which is multinational, look like? And what tests will be applied? And what would be the vehicle with which assets or liabilities that have accrued to such an enterprise travel between creditors or resolution professionals and other stakeholders? These are and we have also seen during COVID a massive re-entry of the state into several sectors of the economy. And most recently in India, we have seen the government pick up the stake, converting into equity the positions they held as claims against Vodafone. In other sectors, we have seen private capital during COVID and the pandemic being not fully able to cope with challenges of that scale. And I think it was a massive reminder that the state is here to stay. The state is not disappearing anytime soon as a vehicle for complex human activity, both commercial and non-commercial. So these are just facets of how personal jurisdiction would work, but in a disaggregated world that we have come to consider as normal today. But it's quite unrecognizable at the time in which this particular convention was adopted in 1972. The jurisdiction by virtue of registration, again, is self-explanatory. There are also features of joint and several liability, acknowledging where more than one state may be at fault, and noting that the launching state is primarily liable, even if there is a private operator that is using such facilities. And this brings to bear the question of insurance. And there are, for example, there are minimum insurance contributions that are expected from private players in many states. And it has become almost a source of competition amongst states to attract the private entrepreneurship talent that exists in the space sector. But that cannot be a race to the bottom because of this principle of the launching state owning responsibility even for private activities conducted within their remit. If I will just, in the interest of speed, move a little quickly. But as I've already mentioned, space is critical in national security in air and space law if we combine the two. And the headlines of the past 2 days about objects which are in zones of the atmosphere below the crowded space object orbits, but well above civil aviation traffic routes. And these interstitial spaces and their significance in military or national security use is a matter of obvious interest. The ASAT questions have also been noted, and there's an attempt even as recently as December 2022 in the UN General Assembly to try to note with great concern the kinetic ASAT tests and to address the destructive direct descent direct ascent of anti-satellite testing and missile testing, and whether this requires even as something severe as a ban. And also added to the mix of VUCA elements is what shall I say? The world is perhaps permanently changed after November 2022 and the launch of ChatGPT. So in addition, and also we have seen, I think it was Rolls-Royce that has announced that it would use a micronuclear powered technique for propulsion for some objects. So here you see the collision or the interaction rather of multiple international legal regimes, interaction of space law regimes with nuclear law regimes, the nascent emergence of control over automated technologies and automated algorithms that are at play, and what then happens if the algorithm itself runs amok from the original parameters of its operation. And many of these technologies, as shown by the collaboration of OpenAI, has multiple stakeholders, not just one. The ownership of ChatGPT or OpenAI cannot be ascribed to, let's say, Microsoft, who have contributed heavily, or indeed any other company per se. And so this amorphous contribution within the private sector as well to create cutting edge new technologies and how they interact with each other. This is where I think the interstitial spaces is where we see the most challenging aspects of our times. I won't go into the ASAT too much, but I'm just saying it is one other factor for us to consider. I'm giving you, I hope, a flavor of many other such factors that have complicated the interpretation and application of these conventions. But staying with the potential debris related issues as well, many of these, the reason why I'm pulling out ASAT as an example is, well, so far at least, the ASAT testing has been by states. Now, what is to happen hereafter, where non-state actors or get the capability to conduct such ASAT testing or indeed destructive capabilities as well? And so these are aspects that that one before we encountered in fact, at least job of lawyers and jurists to have a kind of wargaming exercise, and maybe Chirag would recommend that to you in a future session where we're able to gameplay, role play scenarios and build those scenarios and build and improve upon current juridical tools so that they are made perhaps more fit for purpose than merely narrating in a presentation or a discussion form. Some sort of a gaming exercise would, I think, be very useful, especially in the university. There also is the topic that I mentioned earlier, which is the manual on international law applicable to military use of outer space. This is for peacetime use. I was quite inspired when I came across them. I wrote in, very welcoming, and unfortunately, for a personal circumstance, one of our team members was not able to travel to Canada and participate in the deliberations. But I did participate virtually even before COVID, and they were kind enough to permit that virtual participation. But it's worth reminding ourselves what their mission statement was and is, which is to develop a manual that objectively articulates and clarifies existing international law applicable to military use of outer space in time of peace, including in times of rising tensions, and if considered appropriate in times of armed conflict. And so I think efforts such as this will now soon increase apace, given the interaction of multiple regimes. I've mentioned state-centric activity already. Coming to the liability regime per se, the kind of underlying commercial basis of any form of risk taking matrices that need to be developed by states or by corporations before they invest in a long-term, high capital intensive area, be that in space or be it in nuclear, is some sort of understanding of what that quantum of liability could be. And so commercially speaking, there would be an obvious need for clarity on what the quantums of liability could look like. Now, there may be limitations which are temporal. For example, France included a limitation term in its domestic space legislation, looking at the liability of private entities, saying that they would end after the fulfillment of obligations set out in the license or the authorization for the activity, or at most for 1 year after such fulfillment, after which the government becomes liable in place of the private entity. The other example could be from Austria, which offers a lower insurance cap or a complete waiver from the insurance requirement for activities undertaking public interest, including science, research, or education. And as there are, let's say, bilateral or multilateral state activities, you may find examples of reciprocal waivers of liability between persons involved and the chain of supply chain of services and manufacturing that is required to sustain such activity, which requires high levels of collaboration amongst many states. And lastly, I end with the quick look at the PCA rules. Again, Arthur has made reference to it already. He's pointed out the three main contributions difference. And talked about the specialized panel. But I can say again, from the perspective of a generalist, that sometimes learning how to learn is perhaps the most important skill that we will need to have for the remainder of decades to come. And what does specialized scientific expertise, for example, mean when you have information available immediately at hand, when you have now in 2023 January tools available to summarize that information and convey it to you using algorithmic tools, so that in education, there's a concept called inclusiveness. So, for example, if there's a child in school who's a slow learner, or if there's a judge of the tribunal or a member of the tribunal in an arbitration who's a slow learner, it can happen when some people are quick on the uptakes, not. The concept of inclusiveness in education is to meet the learner where they are, and able to and take them through the learning journey. So I would ask whether it is this oft-quoted need for specialized expertise, or whether it is the ability to learn and to adapt and apply. Because even the specialist, mind you, who's a specialist in one domain, will have to learn. Nobody is exempt from learning. Even the specialist is not exempt. And even the specialist in the domain will have to learn perhaps more about juridical principles that are applicable. We have to learn from analogy where the developments are in other sectors. And so there's an element of learning in everybody's professional life in the dispute resolution space. So I would ask whether whether in the realm of space, for example, it was said that tech companies was another example which they did not like arbitration because they thought it was heavily peopled by people who don't know enough about circuitry. But having done cases, I've been again a student of circuitry and integrated circuits and semiconductor technologies to be able to conduct my cases. And I stopped studying science in 10th standard. But thankfully, my teachers instilled the ability to ask questions and learn, irrespective of whether somebody called them stupid questions or not. And so a confident learner, I would posit, is perhaps a quality that one must look for. And you don't see that as being called out as what are the attributes of a person you're looking for as an adjudicator or a mediator. Also, and so I would maybe even question the premise that has drawn institutions to saying some of these areas, because the other areas have tried and they've failed. We have to learn from those examples as well. One such example is perhaps in the financial sector. In Hague, there are multiple institutions that have come up for dispute resolution, claiming to be fit for purpose for a specialized sector, but they haven't seen much traction. We have not seen much traction in the institute, for example, called Prime, dealing with international financial disputes. There are other sectors as well where specialized, they had no, to use an Indian expression, khata nahi khola, which is they didn't open their account in attracting users to use their facilities as opposed to. So I think before we multiply the levels of organizations and rules, we need to cogitate and contemplate what is the type of skill we're really looking for in the professions we need to deal with. With that, I once again thank my colleagues who helped me on the presentation and thank the organizers for giving me the opportunity to speak. Namaste.
Thank you so much, sir. I thank Mr. Shreya Jaisema for his enlightening words and for being so eloquent and comprehensive. Thank you very much, sir. We now move on to the next panelist, Professor Franz Wonderdunk. The next speaker for today has written more than 180 articles and published papers, including the first comprehensive handbook on space laws in 2015. A professor of space law at Nebraska University, Professor Wonderdunk, in summer of 2008, was nominated as the first lawyer ever member of European Space Sciences Committee or the European Space Foundation. He has given over 200 presentations at international meetings and was a visiting professor at over 50 universities and academic institutions across the world on subjects of international and national space law and policy, international air law, and public international law. Agency, United Nations, and many other such organizations of pristine repute. He is the Director of Public Relations of International Institute of Space Law and member of the Netherlands in International Law Association's Committee on Space Law. He's also the owner of Black Holes BV, a leading consultancy Company for Space Law and Policy. It is an absolute privilege to have you on our panel, sir. I hereby invite.
Sorry. Thank you for that. Can everyone hear me? Because I suffer a little bit of intermittent connectivity.
Yes, sir, you're audible.
Okay, thank you. Thank you for those kind words, and thank you for inviting me. I've listened with great interest to the previous speakers, and of course quickly noted that they are already dealing with a number of subjects that I'm going to deal with as well. So the only thing I can say is that I'm probably taking some things to a more general, overarching level, and also relating it to some aspects of space law that have not been discussed so far, which could still give rise to disputes, but many of the details have already been provided by the excellent speakers before me. So I apologize if to some extent I might be repeating things. I will try to share my screen, and in particular, am I allowed to? Let's see. Allow Zoom to share your screen. Oops.
Sir, are you finding the option to share your screen, or should I make you the co-host?
I'm trying to share it using the share screen open system preferences, but
Just a second, sir. We will just allow you to share the screen, sir. Sir, we're making you the co-host in just a second, sir. Sir, you can start this. You can start the session. We'll just give you the option of sharing in just a second, sir.
I apologize for that. But now, can you hear me again?
Yes, sir. Sir, we can hear you, sir.
Okay.
We'll just give you the option of sharing the screen in just 30 seconds, sir. Yeah, you have gotten the option. Yes, sir.
Yeah, I think I'm able to share my screen now.
Yes, sir. It is visible, sir.
Although I have to move this a little bit out of the way. What's going on? I'm screen sharing, but you see things which are not interesting. Here you go. Do you see my title slide now?
Yes, sir. We are seeing space law and how to settle relevant disputes. Yes, sir. It's visible.
Okay, thank you so much. Okay, thanks once again for allowing me to chime in from, I'm sorry I can't be with you physically. I'm currently in Philadelphia in the United States. So it is morning here, but I'm happy to be able at least to give some thoughts about the more broader context of space law. I wasn't sure also, to be honest, how much of the audience is familiar with many of the details of space law. So that's why I thought I'd also give a sort of general overview of what it is about, because as you can imagine, when you talk about being a space lawyer, some people still raise their eyebrows and really question what the heck is that. Even a reputable newspaper as the Huffington Post only a few years ago realized that space lawyers are a thing and that space law actually exists. Indeed, at the time we talked about the future of cosmic mining or space mining. I heard that some of the previous speakers alluded to that as well. It is, of course, one of the hot topics in space law today. Things are moving pretty quickly, I would say, and we may soon see, hopefully, at least within the next 5 to 10 years, not only actual space mining operations going on, but also a sort of general consensus on the legal parameters to that. But there may obviously also be disputes, because cosmic mining, space mining is potentially about very valuable resources, and if there is a competition for valuable resources in the international field, you can imagine that that may give rise to a number of international disputes. And the question, of course, is how those disputes then would best be solved. Now, again, if you talk about space law, we should realize that space law is something which in one respect is not different from any law. And I'm always reminded of a cartoon in the New York Times more than 10 years ago, which said that wherever you go, the taxman goes. I would suggest that it actually should read, wherever you go, the lawyer goes. And that, of course, means that wherever humans start to be active, the law soon follows in order to solve conflicts, but also to more generally provide for predictability and stability in the international relations. And this is, of course, not principally different for outer space. And that is also why the origins of space law really go back to 1957, when this small metal sphere, you may recognize it as Sputnik 1, the first Soviet satellite, or the first human-made satellite altogether, went up into outer space, orbited the Earth a number of times, caused a huge political scare in the United States, but also raised legal issues, obviously. Luckily, I dare say, within a year, the UN got involved. Both the superpowers at the time, the Soviet Union and the United States, agreed that the UN was the most appropriate platform to discuss these legal questions. And within a few more years, we actually had a first UN General Assembly resolution on space. Now, as it has been mentioned, General Assembly resolutions are not binding legal documents, but they still put a point on the horizon and an ambition to have states agree on certain principles, including legal principles. In any event, this became quickly history, because most of the principles that developed in that resolution and a few later ones were then converted into the first binding international treaty, which is, of course, what called for short the Outer Space Treaty. I should say for short, because here you see the full name, Treaty on Principles Governing, etc., etc. It's also sometimes called the Principles Treaty. It doesn't purport to deal with any rules in great detail, which of course means that also for disputes, it then may require a lot of additional information and legislation and law to be able to pinpoint at where exactly the borders of legality or illegality are being crossed. Now, it's important to note that the Outer Space Treaty was ratified not only by the United States and the Soviet Union, but by all major spacefaring nations, including, for example, India, but also countries like China, the Western European countries, Japan, Brazil, Nigeria, etc., etc. What happened in the first period of the space age was that space activities were still very peculiar, and that also diverged into the law. If you want to take a very shortcut on this discussion, there were basically three main characteristics of space activities. One, they were very technologically oriented. You had certainly originally to have an extraordinary amount of technical knowledge to do anything relevant in outer space, which then also meant that it cost an enormous amount of money. And in spite of all the money and the technology required, things went regularly wrong. Things still can go wrong. They will continue to go wrong. And that's, of course, where some of the liability questions that were addressed by previous speakers also came in. These three main characteristics originally caused space activities to be very much a state-oriented activity. Because the only entities that would be willing to spend so much money and take so much risks there would be states for three particular reasons that didn't touch upon any private sector. interest. So the most obvious one was, of course, the military interest. And the space race between the Soviet Union and the United States was part of the Cold War at the time. And until today, the dual use aspects of space activities are obvious. A launcher of a peaceful satellite can be very easily converted into a missile carrying a nuclear weapon. A second rationale for states to go into space was what I would call prestige. In particular, in the Cold War era, the United States and the Soviet Union were competing for the interests of the rest of the world, in particular the non-aligned countries, and they wanted to show that their political system, respectively the communist and the free enterprise system, was superior, and the best way they could show that, they thought, was by winning the space race. So a lot of money was poured into space for those reasons. And then the third one was science, finding out more information about the origins of the universe, the origins of the Earth, the origins of the moon, things like that. And if you look at those three rationales, it is clear that only states were interested in that. So only states were interested in investing money for those reasons. And since only a few states actually had the technology and the money to do that originally, there was a lot of international cooperation, and it was clear that international space law, as a consequence, was also very much focused on state orientation. So even in the United States, which is generally seen as a champion of private enterprise, there was a general understanding that space law in the 60s would have to address states, and that space activities were primarily something for states to undertake. So states were the makers and breakers of space law, makers in the sense that they create the treaties, that it was their behavior which determined whether some customary international law rule had arisen. But they were also, and that is of course not something specific to space law, because that is generally applicable to international law, but they're also the breakers of space law in the sense that all the obligations and the rules and the rights contained in the Outer Space Treaty and some of the follow-on treaties were very much focused on states. Previous speakers have already given some quite specific examples thereof. Think about the liability aspects, that states are liable for activities of the private sector, at least in the international realm, which is very unique. Only in the realms of oil pollution and nuclear pollution, we have seen some acceptance of state liability, even if there is a sort of primary tire liability for private operators in those contexts. But space is really from the start, again, as long as damage has an international flavor, is oriented towards states. And the launching states concept, as was discussed before, is targeting a launching state or a number of launching states of a space object to be held liable for the damage caused thereby, regardless of the level of private participation. So that, of course, meant that space law was very much focused on states. And space law, what is international space law? Space law is treaty law. States agree on text and then decide to become a party or not. That is where they decide to join a treaty or stay out of that regime. Luckily, the Outer Space Treaty is one example, as I pointed out before, where indeed the overwhelming majority of spacefaring countries have signed up to. So it will be very difficult to argue that it doesn't apply to space activities, and that this actually leads to many people agreeing that the Outer Space Treaty is also binding as a matter of customary international law, at least its provisions. Customary international law is this other source, which is of course a much vaguer source of international law. It consists basically of what I call that's not my term, what we call in international law the custom, the standard approach to addressing a situation by states. And if states indeed in a fairly uniform manner address certain situations all the time, then that is a custom. And if there is an additional sense of a legal obligation, the opinio juris, then that translates into an actual legal obligation, customary international law. Now, if you look at space law from that perspective, you should realize that space law has more to it than just the space law treaties. Actually, one way I try to indicate that is by a concentric core plus circles approach. At the core of space law, you have international law, which is exclusively and comprehensively dedicated to outer space. And the key example thereof is, of course, the Outer Space Treaty. We will see a couple of more examples in my next slide. But this is not all. And if we talk about international space law and disputes about international space law, we should realize that in addition, there are many other legal regimes which have an impact, sometimes a major impact on space activities, or at least certain space activities. And by that very token, are also actually part of space law and may help to solve disputes regarding space activities. So we have what I would call the northern part of the first ring, where you do have international law, which exclusively focus on space, but doesn't address all space activities. Clear examples are the Intergovernmental Agreement on the International Space Station, which only binds the 15 or 16 countries that are joining the effort of the International Space Station. A country like India, which is not a partner to that, can completely ignore whatever is agreed in that agreement. But by contrast, countries like the United States and Russia, which are party to the ISS operations, do have to comply with whatever is agreed in that treaty. And as a consequence, if there is dispute on that, they have to look for an appropriate dispute settlement mechanism. Then there is also obviously a southern part of the ring, of the first ring, which is essentially the opposite, namely regimes which are not exclusively focusing on space, but include all space activities by inference. Some of them are much older. We've had in this session today earlier discussions about the ITU. Now the ITU is, of course, more than 100 years older than the Outer Space Treaty. So it was developed, the whole regime of dealing with international use of radio frequencies was developed well before anyone figured that that might have a relevance for space. But at the same time, when in the late 1950s and early 60s, it became clear that space activities were on the agenda and that they needed the use of frequencies for absence of harmful interference, to arrange for coordination to avoid harmful interference, then that became applicable to outer space as well. And since no space activity is possible without radio communication, you can say that the ITU regime, by that token, has become part of space law as well. Which means that a lot of disputes which focus specifically on these radio frequency issues can, even if they have an impact on space, can probably be better solved through the ITU regime than through whatever the Outer Space Treaty provides. And as we've already seen, that is not much. Around that, there is a second ring, which is comprised of all the international law, which is not only addressing space, but, and to the extent that it is addressing space, doesn't address all space activities. Think about the application of patent rights to outer space. It only applies to a specific type of space activity, namely those who lead to inventions where the inventors may seek patent rights to protect their interests. But if that is the case, then obviously for that particular type of space activity, there is possibly a solution in the patent treaties to solve disputes about patent rights and the violation thereof. I didn't include in this slide yet a further ring, which is actually the ring of national law, which is usually from the international perspective used to interpret international law, but I will leave it at that, not to make things too complicated, and focus for the rest of today, of my talk at least, on the inner core and what does that provide. Well, we talked about the Outer Space Treaty, and these are the current numbers. So an overwhelming group of important spacefaring nations are parties to that. It really is the general framework for outer space activities. It is, as I said, by many considered to be customary international law, but it at the same time was a principles treaty focusing on broad, general, all-encompassing principles rather than on specific hard rights. So in order to deal with those issues that immediately called for further specific international law. There were a handful of follow-up treaties organized. One dealt with the rescue of astronauts, and this is again not the full name. Some people refer to it as the Rescue and Return Agreement, which points to the fact that it doesn't only talk about the rescue of astronauts, but also to the return of space objects which lands in someone else's territory or in somebody else's jurisdiction, and there is an obligation to return those. There is the Liability Convention, which is already referred to by earlier speakers, which specifically elaborates Article 7 of the Outer Space Treaty, which obviously addresses liability as a principle, but doesn't do much beyond that. And it is the Liability Convention where you can make the distinction or find the distinction between absolute and fault liability, and where that applies, you can find the fact that compensation is in principle without limits, and you can find some procedure elements, including, of course, when it comes to dispute settlement, this famous set of clauses on the Claims Commission. The last convention which I want to mention here is the Registration Convention, still 8 years only after the Outer Space Treaty, to provide for the details of registration of space objects and what that means. So in terms of the substance, I'm now going to run through a number of slides which give you a general idea of the kind of obligations that the Outer Space Treaty has developed, which is, and some of them have already again been touched upon by previous speakers, but which give you a general idea of where disputes may arise as far as the Outer Space Treaty is concerned. So there are a number of general principles, and I dare say that the most important one, the one also currently being discussed very prominently in the context of all these space mining efforts, is Article 2. Article 2, and I quote it here almost in full, is saying that outer space, including the moon and other celestial bodies, is not subject to national appropriation by claim of sovereignty, by means of occupation or use, or by any other means. So what does that mean? Well, this harks back to the history of humankind on Earth. If I'm sure many of you have learned in history classes that in particular Western European nations back in the 14th, 15th, 16th, 17th century had the habit of going to other parts of the world, which they considered from a very European-centric perspective to not comprise states or even civilizations, to plant their flag there, call that a colony for the motherlands. And of course, India used to be part of the British Empire as a consequence thereof back in the days, but also my own country, the Netherlands, was part of that. Now, obviously, since the United Nations Charter, this idea that Western European countries could go, or any country for that matter, could go to another country, another part of the world, consider it, legally speaking, no man's land, even though there might be many people and even developed civilizations living there, call it empty land and put their flag there and say, and now it's subject to the colonial control. That is no longer possible. The UN Charter, of course, is very clear on the fact that colonization is no longer applicable. And actually, since the Second World War, we obviously saw a great wave of decolonization. What Article 2 basically does is saying, this is now not going to happen in outer space either. We are absolutely making sure that in outer space, you cannot put your flag somewhere and call that part of outer space part of the motherland. So even the fact that this is obviously an iconic picture of Buzz Aldrin with the US flag on the moon in 1969, it was never meant to claim the moon or part thereof as to become part of the United States. So it was clear that it was a small step for a man, now we would say for a human, of course, and it was a giant leap for humankind, not just for the United States. And also in other matters, the United States wanted to make very clear that they did not claim any part of the moon to be subject to US territory. Another famous principle goes back to Article 1, which has also been briefly discussed in terms of the benefits for all countries, but it also provides that every state in principle has the freedom to be active in outer space. So that is kind of the freedom, the baseline principle that states are free to act in outer space unless there is a specific treaty or in exceptional cases, perhaps US COGANs, peremptory norms, which prohibit them from doing that. But of course, when it comes to treaties, it's up to the states themselves in their sovereignty to accept limitations to their freedom. But they can only be imposed on the international level. It's not for one state to impose a limitation on the freedom of another. That is sometimes reflected with reference to the Lotus case, a famous piece of jurisprudence in the previous international court back in the 1920s, where it was announced that international obligations resting upon states cannot be presumed. You have to be able to point at a specific treaty or other customary law rule to make sure or to point to an obligation that a state might then have violated. A few further important principles. We spoke about the Registration Convention, which elaborated actually Article 8 of the Outer Space Treaty, to the extent that now the registration of space objects is clearly giving rise to the right of states to retain jurisdiction over space object, as if this was a piece of quasi-territory of the flag state. It's very similar to what we've seen in ships and aircraft. You can now also apply that to spacecraft. Technically speaking, it doesn't provide nationality to spacecraft, but the effects in reality are the same as providing a nationality to a ship or an aircraft. In this interesting extent, it also extends to the personnel thereof, even if you look at the picture on the right-hand bottom side, someone leaving the space object, but usually returning within a few hours back to it. Those astronauts on extravehicular activities would still fall under the jurisdiction of the registration state. Last key principle in a general sense is kind of a fallback one. Article 3 of the Outer Space Treaty says that the UN Charter applies in principle to outer space, which of course, and in view of the time, I won't go into too much details here, but does address issues of the territorial integrity and political independence of a state and the right of self-defense, or the right of, or perhaps even the obligation of mandatory action. I said this was the last principle. There are two more which are of key importance. They have been touched upon already, and they provide for the key linkage to private sector activities. Given the original state orientation of space law, we've seen that states are responsible for private activities in outer space, even if they are national, which requires formally authorization and continuing supervision, which in practice is usually interpreted as the need to establish national space legislation. This is the state of play today. You see that more than 24 countries, unfortunately India is not yet amongst them, have created a national space law regime translating the international obligations from the space treaties to obligations for their private sector interested in operating in outer space through basically an authorization regime, or you can call it a licensing regime or a permission regime. That is just a matter of terminology. Now, of course, there's the twin brother to Article 6, which is Article 7, as further elaborated by the Liability Convention, which again focuses on states. And just to summarize what others have done in greater detail, liability for states includes liability for damage caused by the private sector. And even though there's no formal requirement in Article 7 or the Liability Convention to conclude national space legislation, all of them logically address this issue of liability, because when the state is going to be held liable for what a private sector entity licensed by them is doing, then obviously they use the license in the national space law as a way to have recourse against the private operator. Okay, for the final part, that then sort of gives me a few ideas on space law and dispute settlement. And it is interesting to note that space law originally went by the presumption, well, let's try and solve any disputes by diplomacy. So if you look at the UN space treaties, there is no specific dispute settlement provision there. You can refer to state exclusive mechanisms such as the ICJ, but as we discussed before, they are limited to to states that have actually accepted that jurisdiction. There is a possibility to go to some extent through the ITU dispute settlement mechanism. And when it comes to trade-related issues and the access to space communication markets around the world, perhaps the WTO could play a role. And then, of course, at the national level, there are all these court systems and arbitral tribunals, but they only have a limited scope in terms of being limited at the national level. The exception is the liability convention, but even there, the idea is that first, any dispute on liability should be solved by diplomacy, and only when the dispute is not settled within a year, the possibility is for states to call. It's a possibility, it's not an automatic system, to call for the establishment of the Space Commission, which I would call quasi-arbitration, because while it is true that opposing states cannot prevent the Claims Commission process from going forward, an award is only binding if all states involved have in advance so agreed. And you can imagine that if a state feels likely that it will be punished by liability, it will probably tend not to recognize that, and it stays at the level of a mere recommendation. Beyond that, or as a result of all that, there's a patchwork of mechanisms going also through this concentric core and circles idea. The ICJ is limited because it only allows states that have accepted the jurisdiction. Space law is a very special field of law, and others are limited in scope. The Liability Convention only deals with liability issues. There are some intergovernmental organizations like the old Intelsat or Inmarsat, but that is limited to disputes within the context of these organizations. The same applies to the governmental agreement on the International Space Station I mentioned before. And then, of course, national courts can only adjudicate national disputes following national laws. They cannot adjudicate between two or more states. That was all good and well for maybe the first 20 or 30 years of the space age. But then we saw the paradigm change. More states became involved, many, many more states, including states small and poor to a large extent. And of course, because of the practicalization of space activities, the fact that you can use it for communications, for Earth's remote sensing, for navigation, it meant that the private sector saw the dollar amounts on the horizon and became interested in joining as well. So the main question now, and we've touched upon various elements thereof throughout this session, is how should we, how could we make private commercial operators fit into this regime? And how to make sure that they, on the one hand, comply with the regime, that they indeed are held to whatever the international treaties, which are then hopefully guided through national space legislation to become obligations for them as well in a direct sense, that their activities recognize the public interest in space. Think about equity, safety, security, environment, the science, things like that. And on the other hand, if we accept that the private sector can be a valid contributor to the benefit of humankind in outer space, and I dare say that by far most countries accept that premise, at least in general terms, then you also should find a way to take their legitimate interests into account. The main answer still is, well, the Outer Space Treaty provides the legal structure. It is a global commons, which makes that states are free to explore it and use it as long as they comply with the obligations. And private operators are only allowed within that context. The freedom of the Outer Space Treaty does not directly apply to private enterprise. And if you just think about the formerly communist Soviet Union, where private enterprise, because of the ideology of communism, was not admissible in any event, you can see where that goes. But that also dictates any efforts to settle disputes. And that's, of course, where the PCA optional rules, which fortunately have been discussed in greater detail as well already earlier today, come in. So here you finally have participation by private entities in dispute settlement, basically on an equal level with states. There's a maximum flexibility for parties to the dispute. Any disputes that the parties agree to refer to these optional rules, whether it actually includes the word space or not, that's irrelevant. As long as the parties agree that this is a good mechanism, they can use it. Also, the parties can, which is also obviously a normal feature of arbitration, can be very elective as to what laws they want to apply to the dispute at hand, whether it's international law only or what international law, or whether they want to include some national law elements. The default size of the tribunal is 3, but there's again a lot of flexibility depending upon the wish of the parties to include very special expertise, or on the contrary, to keep it as cheap as possible. They can use expert witnesses, we've heard that before, and at least it provides for a binding settlement. So it is the final solution, hopefully, for many of the future problems. With that, I conclude. There are obviously many questions left, but thank you for your kind attention.
Thank you so much, Professor Dunk, for an interesting speech. We have a question in the chat box. The question is, what are the contradictory elements between Artemis Accords and Moon Agreement, as the former allows extraction of lunar resources for appropriation?
That's a great question. Well, first we should note that on the one hand, the Moon Agreement is a legally binding treaty, but only for the 18 states that have ratified it, which do not include the United States. And when I say 18, I should say that very recently, the Saudi Arabia has, one of those 18, has announced that it will step down from the Moon Agreement. So that already indicates the problems that the Moon Agreement poses to those who are interested in undertaking lunar resource exploitation, lunar mining, if you will. On the other hand, the Moon Agreement for the 17 remaining states remains in power, but it is not ratified by most important spacefaring nations. I think it's fair to say that Australia is the most powerful space nation, which is a party to that treaty. Australia has also signed up to the Artemis Accords, so it's going to be an interesting question. On the other hand, the Artemis Accords are not a treaty. It is not, they are not concluded at the level of states. They are concluded at the level of space agencies, and the general idea is that it is a living document which spells out the basic agreements among the participating agencies. And of course, it's a US initiative because NASA has started this Artemis program. But the idea is that those other space agencies who want to join this international cooperation effort should then at least agree on a general level on principles, because if you have very different views on fundamental elements of the Artemis plans, then it's probably better not to start the cooperation, because then you get into real trouble. Artemis Accords indeed promote the idea of private mining. So if you as a country are dead set against that, if you don't like that idea for whatever reasons, for example, because you are a party to the Moon Agreement, or there may be other reasons as well, then I think you should think twice of signing the Artemis Accords. Although having said that, it is an open agreement, and in principle, it is still possible, as if you are one of those agencies in the context of the Artemis Accords, to influence the future development. Now, the reality is, of course, that certainly so far, the United States is by far the most powerful country within the Artemis Accords. So its ideas will probably be pretty much leading where it's going, but that is not necessarily a given. So the conflicts are certainly there, but they are not there yet at a legal level. But given the example of Australia that I mentioned, sooner or later, you might have to make a choice. Either you stick to the Moon Agreement or the general idea that private mining cannot currently go on the Moon, or start to be developed on the Moon, or you want to be a partner of the Artemis agreements, and then you have to basically agree to that principle.
Thank you for that. So you mentioned about quasi-arbitration, where states will have to arbitrate, but for an award to be binding, both the states must agree in advance. Do we have any instances where states actually agreed in advance? Because usually no state would want to make a binding commitment.
Yeah, no, and as a matter of fact, the liability convention, it is even, let me put it this way, it's even debatable whether the liability convention has ever been activated as to the claims commission. There's one case that's where the dispute goes. In 1978, there was a Soviet nuclear-powered satellite, the Cosmos 954, which disintegrated over Canadian territory, spread nuclear polluted, because there was a nuclear generator on board. There was nuclear pollution. It spread out over a large part of luckily uninhabited Canadian territory. And Canada asserted, in line with the principles of the Liability Convention, it of course quickly found out that the fragments came from a Soviet satellite, so it asserted the claim against the Soviet Union, saying that following the principles of the Liability Convention, they held the Soviet Union liable, and they claimed more than 9 million Canadian dollars of damage. So in their claim, they used the reference to the Liability Convention. Now, if you look at the Liability Convention, as I said before, even the Liability Convention assumes that when there is a dispute about liability between two countries or more countries, you first seek diplomatic negotiation. And what happened was exactly this. Both Canada and Soviet Union engaged in diplomatic negotiations. The Soviet Union, in the end, agreed to pay about 1/3 of the original claim, so a little more than 3 million Canadian dollars. But in the claims settlement, there was no reference to the Liability Convention, and there was never a claims commission because the Canadians then accepted this settlement in the claim. So whether you think that this formally engaged the Liability Convention is perhaps a matter of words. What is important to realize is that the Soviet Union basically said, well, we don't accept this as a precedent, so we do this payment ex gratia because we are good citizens of the world. We recognize that this, in this case, it was a Soviet satellite, which to me also means that the Liability Convention was kind of used as a stick behind the door. In other words, if the Soviet Union wouldn't have come across with any offer to compensate and would have really stuck to its guns, then the Canadians might have moved on and say, okay, then we're going to get this claims commission going. And even though it would not have given rise to a binding result, most likely, because I would assume it is, of course, it can't be proven, but I would assume that the Soviet Union would then have said, no, we think this is just a recommendation. And but they would have, of course, been having a terrible political backlash, because everybody would now suddenly see the Soviet Union, which was clearly liable because it was a Soviet satellite, not willing to pay. It would make a very bad impression. And in the context of the efforts of the Soviet Union, again, to show the rest of the world that communism was the superior political system, of course, you can't then look like you're a bad guy who ignores international obligations. So that's why the Canadians sort of hinted at the Liability Convention, and the Soviet Union realized that if they wouldn't do anything, they would probably face this public relations failure. And by offering to pay at least a bit over 3 million Canadian dollars, they sort of took out that risk. That's a little bit, and that's as close as it got. Since then, there was never any effort to include the Liability Convention or to invoke the Liability Convention. There have been a few in-space collisions, but with the exception of the Cosmos Iridium collision a number of years ago, they were all between dead satellites or dead pieces, so none of the launching states bothered to use the Liability Convention because there wasn't real damage at stake. Only in the Cosmos versus Iridium collision, there was a lot of, well, at least the Cosmos satellite had been the dead satellite, which had been running out of control since 10 years, but the Iridium satellite was a fully operational communication satellite. But what complicated the matters there was that, of course, for the Cosmos satellite, it was clear that Russia was the launching state as a successor to the Soviet Union. But the interesting thing was that Iridium, the private US operator, had also sought this particular launch and paid for that particular launch on top of a Russian rocket from Baikonur, because the Russians were offering a much cheaper deal than they could find with someone else. So The result was that the Russians were both the launching state on the one side and on the other side. And of course, the liability convention had not foreseen, what happens if two space objects collide and the same state is a launching state on both sides, regardless of whether the fact that the United States could also be considered a launching state, perhaps of Iridium. So in the end, nobody decided to invoke the liability convention.
Thank you. Thank you. Your responses are like review articles. Somebody can probably write a research paper. They are so critical and analytical. Thanks for that. Last question. Can foreign investors, because now a lot of private players are getting into space industry, initiate action or claims against state for expropriation or fair and equitable treatment under investment protection treaties?
Chirag, if I may, I don't want to interrupt, but this is the topic of my presentation. So maybe we can.
Well, I will not answer this question.
Definitely. In fact, we are eagerly waiting for you, Laura, and we understand your patience in waiting till the end. So thank you so much, Professor Duck. It was such a pleasure and honor to host you.
Thank you.
Sorry, but otherwise
you,
there
Laura.
won't be anything
Over to you,
for me
Laura.
left to say.
Yeah,
Over to you, Laura.
right.
Thank you.
Thank you. We started this conference 8 hours before, right? we are in the 9th hour. So thanks to the patience of all the participants who have stayed with us till now. It's night in India. It's close to 10 p.m. in India. So, and I'm sure it's morning, right? So there's a sunshine in Mexico. So please bring that light here in India with your thoughts. And I request the volunteer to give your kind introduction.
I thank Mr. Dung for such an elucidated explanation of space law and thus helping us understand such vast and arduous topic. Thank you very much, sir. Next on the panel, I'd like to introduce Ms. Laura Zelinsky. Ms. Zelinsky is an international arbitration lawyer who focuses on commercial investor-state and state-state arbitration. She has been involved in proceedings before the Iran-United States Claims Tribunal, the International Tribunal for the Law of the Sea, and the International Court of Justice. She has also represented governments and private companies in proceedings administered by the International Center for Settlement of Investment Disputes, International Chamber of Commerce, and the United Nations Commission on International Trade Law. Her practice also covers public international law advisory matters, including advising clients on sanctions and sovereign immunity. She has also worked in leading role on one of the first investor state cases and co-founded Space Arbitration Association in 2021. We are glad to have you here, ma'am, and the support of the Space Arbitrations Association in conducting this conference. Thank you, ma'am.
Thank you very much. And apologies again for interrupting, but a lot of the topics have been covered already, so I need to see what remains. So thank you very much for inviting me. I'm very happy to be able to participate in this great conference, and I'm impressed by the patience of the participants. So I will try to be brief. I will talk about disputes relating to the use of the radio frequency spectrum and about investor-state disputes in relation to the space sector. So I know that you're familiar with the space economy, but I wanted to give a quick overview again over what we are observing at the moment, just because this sets the stage for what I'm going to say afterwards. So outer space, as Franz has explained again, also has been reserved for states until very recently, but has been in the last decade attracting more and more private investment, and ever more companies are entering the space market. So private commercial activities range from the launching of satellites to remote sensing and the development of space tourism, space manufacturing, and space mining. And according to the 2022 Q2 space report of the Space Foundation, the global space economy reached a total of 469 billion in 2021, which according to them corresponds to an increase of 9% with respect to 2020. The latest Euroconsult data from January 2023 say that the space economy grew by 8% in 2022 to a total of $424 billion. So there's a disconnect between the numbers. But I think what we can conclude from this is that we can see that it is a growing industry that is attracting a high level of private investment, which is important for what I'm going to talk about in a minute. And another interesting element to keep in mind is the increase in the number of satellites that are being launched. So according to the same 2022 report, to the 2022 report of the Satellite Industry Association, 2021 saw a 72%, saw the launch of 1,713 satellites, which brought the total number of operative satellites in space to 4,852. And this was an increase by 179% compared with 2016. The United Nations Office for Outer Space Affairs has also stated that it received over 2,000 registrations for new satellites in 2022 alone. And we can expect that this number will increase much further, because I think we are all aware of the plans for large satellite constellations done by Starlink, OneWeb, and Kuiper, for example, as well as a lot of smaller startups that are also planning to launch several hundreds of satellites. And to illustrate this, for example, in December 2022, the United States Federal Communications Commission granted permission to SpaceX to launch an additional 7,500 satellites to space. So if we compare these numbers with the satellites we have currently in space, we can see that the increase is really significant, and we can expect this to cause certain problems. And why I'm saying this today, because as I mentioned, I will talk about investment protection in space. So it is interesting to know how much investment there actually currently is. And I'm also talking about disputes relating to the use of frequencies. And this is very much related to the number of satellites that are actually using the spectrum that is available and the saturation that we can expect by the increase in satellites being launched. So as my colleagues have mentioned and explained, there are 5 international space treaties. But space activities are also governed by domestic space law, soft law, guidelines, and other sources of law, such as telecommunications law, environmental law, and international law in general. So I will start by speaking about the potential disputes that can arise with regard to the use of radio frequencies. So I think it has been mentioned that the increase in satellites being launched is causing a problem with regard to the physical assets in space. So there are more and more satellites, so the risk of collisions between active satellites, but also between active satellites and space debris is increasing. But this is not the only issue. It's the issue that is mostly talked about because it's more tangible, but we can also expect increasing competition over the use of the radio frequency spectrum, because like space, it is not infinite. And so the more satellites there are that will be using these frequencies, the more competition and tensions we can expect between the different operators. It is the International Telecommunication Union, the ITU, a specialized agency of the United Nations that is headquartered in Geneva, that offers the main international legal framework for addressing the technical and operational aspects of satellite communications and the use of the frequency spectrum. So the ITU is managing all radio frequencies and also the use of the geostationary orbit. It ensures that the available radio frequency spectrum and associated satellite orbits are used equitably, efficiently, and economically, and is tasked with preventing frequency interference between satellites. So in practice, under the ITU rules, before a new satellite or system can be launched and used, it must be coordinated with neighboring satellite networks. So before you can launch a satellite, you're supposed to provide the technical characteristics that can determine whether there will be interference between your satellite network and satellites that are already registered. And the result of this coordination process is set out in so-called coordination agreements. And respecting these agreements is very crucial, because if there's interference between the signals emitted and received by different satellites, it can prevent those satellites from operating normally and thereby cause significant financial harm to the operators and obviously also problems to the users. So to understand this, there are rules governing harmful interference, but in practice, obviously, all of the operators have an interest in avoiding this, because it's always two ways. So if there's an interference, it's never just one satellite that is affected, but both satellites that are causing and receiving the interference. So interference can be divided between intentional and unintentional harmful interference. And I'm talking about unintentional harmful interference. There is sometimes politically motivated intentional interference, for example, with a television broadcast that a state or an operator wants to disrupt for political reasons, but that is a different topic that I'm not addressing today. So when a case of harmful interference occurs and the parties have an interest in resolving this, so if it's not politically motivated, they can bring it to the attention of the ITU, and following an investigation, the ITU Radio Regulations Board can formulate recommendations on how to resolve this. However, this is not a binding process, and importantly for private operators, it cannot award damages. So if you experience harmful interference and this is causing important financial harm to you, and you might look to recover the harm that you have suffered, the ITU is not the appropriate body where you can look for this. So in theory, you could think that you could go to domestic courts. And I'm not sure if this has been addressed already, but for space operators or for satellite operators, domestic courts are not the best forum, because if you go to a domestic court, it is very unlikely that the judge will have a background in space law or even a good understanding of the space industry. And also, you like with any other case in the international arena where you have to go to one domestic court, you're facing obstacles such as the language or general familiarity with the rules of a domestic system. So contrary to domestic courts, arbitration is much better suited for international disputes and for the space industry in general, or in particular rather, because in arbitration you can choose expert decision makers, and you can also agree on the language in which you want to conduct your proceedings. And importantly for the space economy, you can also agree, for example, on enhanced confidentiality. So like for space disputes in general, for frequency disputes also, arbitration is a better forum than domestic courts. But then, as I think you all know, arbitration is consent-based. So in order to be able to go to arbitration, you need to agree. So you can obviously, in theory, agree to arbitrate a dispute once it has arisen. But once there is a dispute, it's more difficult for the parties to agree on this. So usually arbitration is agreed in arbitration clauses and contracts before there's a dispute. So how does this relate to frequency disputes? This is actually where the coordination agreements that I mentioned come into play. So coordination agreements can take the form of just purely technical documents that set out the characteristics of different satellite systems, so that that everyone understands what needs to be respected, so that there won't be harmful interference between the two. But they could actually also contain, and sometimes do, additional clauses such as dispute settlement mechanisms, for example. So if two satellite operators have to coordinate their systems in order to avoid harmful interference, and they set out the result of this coordination process in an agreement, they could agree on including an arbitration clause in that agreement so that in case there's a violation of this coordination process by one of the operators that causes harmful interference to the other one with consequential or with economic harm as a consequence, then they could agree to arbitrate such a dispute. And this does not only come into play with regard to actual harmful interference, but it could also be relevant when there is just a dispute over who has the right to use which frequency band, which I understand is already happening and will increasingly happen to the extent that there will be more competition over the available bands. And it is interesting that in 2012, for example, Eutelsat and SES went to arbitration. It was an ICC arbitration to resolve a dispute that had arisen with regard to a coordination agreement between the two. And Eutelsat, for example, does include arbitration clauses in their coordination agreements. I think this is not the case for many other satellite operators, but as you can see, it can be done, and it is already being done by some companies, and it is probably a good practice going forward, just to make sure that in case there is a dispute, you have an efficient dispute settlement mechanism available. So this is about what I wanted to say about frequency disputes. I don't know if there are any questions with regard to this, because then I will turn to investment protection in outer space. So it's a different topic. So in case you want to ask a question about this, maybe this would be a good moment. I think, check the chat. Okay, I think there are no questions, so I will move on. Yes.
Do we have any questions for Laura? Anybody?
Okay. I'll move on to the second topic. So as we have discussed, satellite operators face the risk of frequency interference, which can harm their operations and put into danger their investments. And they obviously also face the increasing risk of physical collisions. And even in the absence of an actual collision, the saturation of at least the lower orbits are presenting a problem for satellite operators, because they have to increasingly fly collision avoidance maneuvers, which cause economic harm in itself, because when you have to move your satellite, this maneuver consumes fuel. And so given that the lifetime of a satellite depends on the available fuel, because once you can no longer operate a satellite because you can no longer move it, usually you have to decommission it. So if you have to fly several avoidance maneuvers that were not planned, this reduces the time you can actually use your satellite, and so obviously has an economic downside for the space operators. So from what I understand, they increasingly try to see how they can recover these damages. From what I hear from economic experts, this can be calculated quite well, but what is less clear is in which forum you could claim those damages and against whom. So those are risks that private investors in outer space are facing. And in addition to these risks that are really purely related to the fact that it is an asset in outer space, investors in outer space face also the same regulatory risks as investors on Earth. So for example, if you have a license to to do certain operations, or if you have a government contract, then you're always facing the risk that the state could revoke this contract or change the conditions of your investment, which would also be a risk for investors. And taking into account that satellites are very expensive assets, or not just satellites, but in general space operations, so even space mining or investment into commercial space stations are very expensive and long-term operations. So any investor in outer space has a strong interest in making sure that his investment is protected. So then how, like, what ways are available for investors in outer space to make sure that their assets are protected? So according to Article 3 of the Outer Space Treaties, space activities are governed by international law, and this includes bilateral and multilateral investment protection treaties. And those treaties offer substantive and procedural protections to investors who invest in foreign countries. The substantive protections usually include protections against direct and indirect expropriation, against arbitrary treatment, and guarantee, for example, principles such as non-discrimination. And the procedural rights offered usually take the form of consent by the host state to arbitrate breaches of the treaty in front of an international tribunal. So international space law does contain certain substantive protections. For example, as has been mentioned, the Liability Convention does set out principles for compensation for harm being caused by space objects that are being launched. But what is less clear for private investors is the dispute settlement mechanism that is available to them. Because as we have seen, domestic courts present challenges for space operators in the form of a lack of expert decision makers and the lack of confidentiality, for example. And on the other hand, the dispute settlement mechanisms contained in the international space treaties, for example, the Claims Commission contained in the Liability Convention, are reserved for states and can be accessed by private investors only through the mechanism of diplomatic protection. So this is why the access to international arbitration provided in the investment protection treaties is an attractive option for investors in space whose investments have been harmed. So there are a lot of jurisdictional issues that relate to the use of these treaties in the space setting. So first of all, foreign investment protection treaties only apply in very specific circumstances. So a foreign investor has to have invested in the territory of a state who has caused the harm to the investment to be able to have a claim against that state. So this is a very complicated question, which I will not address in more detail here because it goes beyond what I think can be exposed in a seminar such as this one. So I will focus on more straightforward questions. So for example, in order to apply an investment protection, in order for an investment protection treaty to apply, there must be a covered investment. And most bilateral and multilateral investment treaties define investments broadly as every kind of asset. So this definition would usually include satellites. And even under the more restrictive interpretation of what constitutes an investment, for example, the one set out in the ICSID Convention, which requires additional characteristics such as an economic contribution, risk, a certain duration, or contribution to the development of the host state, one could argue that space operations would usually qualify because they are long-term, high-value projects, and they also imply a certain risk. So those are the characteristics that are usually defined as constituting an investment. The other issue is that an investment needs to be made in the host state's territory. And one could argue that given that under the Outer Space Treaty, outer space does not belong to any country, it is difficult to see how a launch of a satellite, for example, into outer space could be qualified as an investment in a territory of a host state. But this does not take into account that satellite operators usually have a natural link with the host state, be it only for the fact that at least one state is launching a satellite. And the launching state is supposed to register a space object. So you could argue that the registration and the fact of launching an object would be sufficient to create a link between that object and a state. So for example, if I, as a German national, launch a satellite from the United States, you could argue that if there were a treaty between the United States and Germany that would protect German investors in the United States, that if I can prove that my harm has been caused by the United States, that I could, in theory, have an investment claim against the United States. As I mentioned, this is very complicated because causation is very difficult to prove in space. So let's say there is a collision or you have to fly an avoidance maneuver. It is given that the rules, for example, of who has to avoid whom in which situation, the causality between the harm and the host state will probably be the most difficult element to prove. But as I mentioned, I will not go further into this today. So what is interesting to see is that we have already had investment cases in the space sector, and in none of these, the territoriality requirement was an issue. And that was exactly because of what I said, the link between the host state and the investment had been clearly established through the rights of the respective host states, for example, over the frequency spectrum that was at issue, or about the orbital positions that were being used. And we can also see that that on the merits, the past investor state cases that we have seen have dealt with conventional treaty breaches, so more regulatory breaches, as I mentioned before, and not scenarios that are very unique to outer space. So in the cases Devas versus India and Deutsche Telekom versus India, with which you might be familiar because they were brought against India, arose out of India's revocation of leased S-band frequency spectrum for national security reasons, and Eutelsat versus Mexico related to a provision contained in a concession agreement for the use of Mexican geostationary orbital positions. So we can probably expect that with more objects being launched, there will also be more issues that could qualify as investment cases, and that we can expect more of these treaty cases in the near future. So with this, Franz, given that I interrupted you, I don't know if you would like to add something to this or if there are any other questions.
So I just have one question. Space is critical to national security. There's an increased commercialization, right? These are the two premises. Now, can the state use policing as the justification to expropriate the foreign investment?
That depends on the wording of the treaty. Some treaties do provide for national security interests to, not as an excuse, but for example, if a state had normally breached the treaty for national security interests, the state could still have the right to do it. So this is not the case in all treaties, but some do. But then it needs to be proven really that whatever you were doing was absolutely necessary for your national security reasons. And this was the case, for example, in the cases against India that I mentioned, where the tribunal held that not the entire revocation of the license was necessary to protect India's national security interests. So I think the answer is a balance. Yes, it can to some extent.
A small response to it. You mentioned that it depends on the language of treaty, but
Yes.
if we consider policing as the principle of customary international law, or right to regulate as a principle of customary international law, then even despite the language of the treaty, where the state will have the power to regulate?
That is definitely an argument to be made and has been interpreted in different ways by the tribunals. So I would say in general, if you can prove that this was the only possible way to protect national security or national interests, it is likely that a tribunal would take this into account, but it cannot be used as a blanket excuse to expropriate foreign investors, because that is exactly the reason why these treaties exist.
Definitely, definitely.
You triggered this question. I was a little bit late on finding the you know the mute and video thing, but no, I have nothing specifically to add, Laura. Thank you for your great expose there.
Right. Do we have any additional questions to Laura? I think it was an excellent session and a great exposition on the topics you have discussed. I personally liked the way you presented. Thank you so much. And I hope our participants benefited from your intervention. Thank you so much, Laura.